ಅದು ಮಾಡ್ಕೋ ಈಗ. ಅಲ್ಲಪ್ಪ ಇದು ವೆಬೆಕ್ಸ್ ಹೋಗ್ಬಿಟ್ಟು ಸೈನ್ ಅಪ್ ಮಾಡಿ. ಸರಿ, ಕಾಸ್ ಲಿಸ್ಟ್ ಕನೆಕ್ಟ್ ಮಾಡಿ.
Lordships kindly.
Of judgment.
Lordships kindly, my lord. One mention, my lord. Serial number 90.
Shall
Please.
we wait after the,
Please.
my lord, I just a moment, please. After the pronouncements.
Pronouncement of judgment, seal number 1, Chandrachud A.
Appeal is allowed. Order dated 21/2/2024 passed by the Commercial Court in 36 number 2023 is set aside. The award dated 17/11/2020 in AC number 58 of 2020 before the arbitrator is set aside. The arbitration proceeding shall commence afresh in accordance with law. It is made clear that this court has not expressed any opinion on the merits of the claim of either of the parties. All contentions kept open. Just a second, if both of you agree, the same arbitrator can be appointed.
Yes, ma'am.
On the panel.
Sorry?
She is on the panel, she can be, or that can be left to the center. The center, they have their own rules.
I don't have.
That discretion may be left, they have their own mechanism.
Needs to have some regulation. The agreement is not clear, we may not get that.
Let
Yes.
time frame may be fixed, my lord. For completion of the arbitral proceedings.
Commencement.
No,
No, no,
commencement
it's
and
for fixation of a time frame.
For commencement.
no,
the-
conclusion of the arbitral.
The conclusion that is provided in the act itself.
There is-
Yes,
yes.
For
commencement.
commencement, we can provide.
Yes. Because the respondent is 76 years old.
All right, for
That is the
commencement, we can
We will not seek any adjournment, we will participate.
Accordance with law, even.
in 2 weeks. Can it be within 2 weeks? Commencement,
Commencement.
appointment of an arbitrator.
Yes.
Yes, 2 weeks is sufficient. I am grateful.
Yes, you wanted to make a
Yes,
submission.
please.
Is it in the list?
Please, my lord.
Will be called
Serial-
page
serial-
by page. Just a
Please.
List 1, any mentioning? Page 1, seal number 2 to 5. Page 2, seal number 6 to 13. Page 3, 14 to 18.
Serial number 16, my lord.
16.
Raised for two days time. Senior is
Vacancy
not
stay.
filling.
Just for vacating the interim order filed by the state.
I filed this application
Can be
next week.
next week.
Page 4, seal number 19 to 26.
Serial number 19, my lord. We appear for the respondents. My lord, I have informed the learned petitioners council, my lord. Kindly have it on Tuesday, my lord. I was directed to secure the records. Tuesday, your lordship may kindly accommodate.
Stay may not be possible, council.
23rd.
Please. Even to.
Yes.
Page 5, 27 to 31. Page 6, 32 to 35.
That's 34, my lord. Not feeling well today, my lord. Your lord. I have not informed the petitioners council. My colleague will be there, my lords, to make a request.
Yes.
Grateful.
List 1, admission.
Any other mentioning?
Milord, one submission, Milord. Submission. One submission.
Just a moment, please. Yes,
One matter is preserved pertaining to segregation of candidates in the.
yes, yes,
The recent judgment of NEET.
NEET.
NEET, may I just pass?
yes, sir. We've seen that.
I'll just. Very good.
My lords, in
Lord.
item number 45, my lords, we have just been assigned the matter. We may kindly be given some time to,
Who appears against you?
we are for the respondent, my lord.
And for the petitioner, your worship, no objection.
Can be 45?
Yes, sir. And for petitioner, your worship, no objection to agenda
Yes.
matter.
Yes,
Lord, is serial number 48, my lord.
yes,
I appear for the petitioner, my lord. Similar matters have been filed, my lord. Your lordship have passed orders on 25th July, the May 2024. This may be called after 2 weeks, my lord, because other matters are coming up, my lord.
yes,
2 weeks, my lord.
yes.
Interim order.
Much obliged.
Interim order shall remain.
I'm sorry, my lord. In serial number 19, there is an interim order, my lord. 19.
Yes, any other submissions? Somebody wanted to make a submission which was not in the list. Yes.
There are meeting that there has to be a effort made to segregate.
Court has posed few questions to be answered.
Have you made that effort to segregate? They are not whether it has taken place.
First initial question would be, it has taken place, there is no question that is a given. Therefore, some malpractice has taken place. Therefore, the initial question would be, is the malpractice so deep-rooted that the entire selection is vitiated? If it is, then there is no question of segregation.
Yes, that's the first sentence in paragraph 12 also. But to arrive at that, the process, they would say that the questions are posed, whether the examination, all the examinations are tainted and all the exam centers are tainted, whether they can be segregated, what is the process. And it was sent to IIT. IIT gave a report which are enclosed also. Therefore, even there, they have allotted it to CBI not to investigate. Therefore, in all cases, an independent investigating agency is what they have saying. Never has been seen that the place where the alleged scam has taken place, they inquire and they come to conclusion and they take action.
In this case, is it possible to ascertain as to when the leak took place and when the examination? No,
Then, according to the report, so it's by way of an email.
no, when? I'm
We are arguing a matter without the petitioner being here.
But I'm informed. But it's there in that report. They say the date of the email and all.
The Supreme Court had posed a question. If the leak had occurred in the morning and the examination in the afternoon, then probably the spread is not so wide. Or the impact of malpractice is not so wide. That is one of the logics.
Here, for example, on different dates, they don't say which question paper for each, for example.
Can we list it on Monday or Tuesday? Monday or Tuesday on the top of the list, because we don't want to do anything or say anything without the petitioner being here. Tuesday, top of the list on Tuesday. Admission, still number 2.
I appear for the response.
Yes.
For the appellant. It's a case not where my vendor executes a sale agreement through power of attorney, suffers a decree. Thereafter, he sells the very same property in favor of the first respondent. The vendor doesn't file suit or challenge the decree.
When is the sale by D3 to the plaintiff?
To the
After
plaintiff.
after the
No,
first
no.
decree.
Yes,
After decree.
after the decree. After the decree, they sell the property. The trial court holds that I have not produced the GPM notes which was executed in favor of my vendor. Notes now, notes at this stage, notes I want to file a 2 application. One, not to summon the power of attorney to produce the power of the attorney, or otherwise, not to lead additional evidence by producing the copy of attorney.
The power of attorney is with whom?
It's with the personal, with the vendor, my lords.
D3.
The vendor is the daughter and the power of attorney is the mother of the vendor. He resides in abroad.
They say she's abroad.
Applications are.
Tell us how many people will read E-Sanjay newspaper.
That's their. Not, but the fact remains not, the court notices are also issued.
Understood. See, the paper publication is not a valid substitute, but it is the procedure prescribed. At least you should take out a newspaper, the paper publication in newspaper which has got wide circulation. Even if it is having a wide circulation throughout the country, nobody will read the court notice, but still we will accept it as a proper service. But in a case like this,
That happened, but court notices also sent my lords, but she resides in the very same address. Not in the present case also, in the case filed by them also, they have not appeared before the court. Neither the vendor, the power of attorney, they appear, they choose to remain ex parte.
they have chosen to sell the property to two persons.
Yes, and they don't want to appear in my case and they don't want to appear in the case even filed by them.
So respondent is also a victim. Assuming that you are a victim, respondent is also a victim. The proper course would be, there has to be a fresh inquiry. In that suit, he should be permitted to participate. In the suit for specific performance by you,
Yes.
the defense is available for him to say that he is a bona fide purchaser.
Not but
Assuming that it is a precedent transfer, then he can also say that agreement is invalid or you are not entitled to specific performance for XYZ reason.
But Supreme Court judgments are otherwise not. It is for the vendor not to challenge the decree. The vendor doesn't choose to challenge the decree, not the.
Yes, challenge it on the ground of fraud. And that has been accepted now.
The ground minute that I have not.
Prima facie, it appears to be a case of fraud. Either by the appellant or by the vendor.
By the vendor only means. Not, anyway, I'm not, I will take a chance to summon the.
Is it vacant?
No, I have my
No,
objection.
is it vacant site?
It's a vacant site almost. Only two square shed is there. I have purchased the property in 2010. 2010, mother gave a gift to the son. Son filed a suit in 2015. Subsequent to the pendency of the suit, he took the position from the execution side. Without disclosing the pendency of this case, challenging the very decree before the same court in the other court hall. My lord, the agreement of sale is executed on a presumption the daughter has given a power of attorney to mother to execute the sale agreement. But nowhere in the suit, they have produced the power of attorney. Even if it is produced, it is an inadmissible document as it is the GPA was executed in a foreign national. NRI, it has to require adjudication under section 3132, certification under section 41. This is not happened. Now on a presumption, they played a fraud on the court. They did not assist the court in giving the correct documents.
That's second. You also purchased through a power of attorney.
Which was not,
There's a different power of attorney.
that
Attorney.
power of attorney,
Same power of attorney, different power of
a
attorney.
different property which was adjudicated.
No, different power of attorney or same power of attorney.
Different power of attorney.
But same.
At a later stage, idu 98, nan kodkondaga 2008. So later, now the all cash transaction sale agreement, no registered agreement, stamp paper is in the brother-in-law name. So fraud cannot dwell together. Justice and fraud cannot dwell together, my lord. There is a latest judgment of now Uma Devi versus Nambiar, 2022. Justice Ramasubramaniam versus Hemant. Unauthorized sale cannot even deliver the possession. I'll place your lordship.
All right. He says he's filing an application for
This
production
could
of.
not be achieved.
No, just a second. He's saying that he's filing an application for production of document, which we can't prevent. He can file it, he can object to it, then we have to consider it on merit.
No, my lord.
But all original
The
documents
two
are.
applications of this nature, 41 Rule 27 will be considered along with the main
Correct.
appeal.
He says-
Another application to summon them.
No, sir. He says he's filing the application. We can't prevent him from filing.
Yes, your lordship. I agree, your lordship. There is a fraud.
No, you file
The-
objection.
Allah, there is a fraud, your lordship.
They have
Your
purchased
lordship
they have
last attempt,
They have purchased the.
make a
property
mention whether you have produced GPA. They took a time on a presumption that I will verify the records and submit. Now on the judgment in para 30, page 30, para 15, clearly says there is nowhere GPA was produced either in this case or in the earlier case. Is it not a fraud on the court, your honor?
Understood, sir. We can consider these aspects if the case is taken for hearing on merits. He
And
says-
records has also been called for this reason.
All right, he says he's filing an application. We should allow him to file an application, whether it will be allowed or not, that's a different story. You are entitled to file objection.
Please, your lordship.
You
Then-
file it in the registry.
Then my one more objection is, I took a time, I gave an undertaking that I will not precipitate the execution. Execution is on today. No, I cannot stand for the stay because I am the bona fide purchaser without any notice. And I am not a party to the earlier proceedings. My adversary was a party.
For this reason, we asked the question whether the land is vacant land or something.
Building of 2 squares building, unoccupied by
Not
anybody.
All original documents, deeds are with my custody. How did they purchase? Not even they say fraud. How did they purchase the property without the original documents?
marriage.
All original
No,
documents.
I
with my
want a
custody.
terms for a stay of the operation of the judgment, my lord. Let him deposit 2 lakhs per month. That property worth 2 crores. ISRO layout,
It's a vacant land, vacant.
vacant site with two squares. That itself cost you about 15,000 rupees per square foot.
Are you intending to sell it?
No, my lord, no, my lord. Value I'm mentioning.
But there is a sale deed in your favor,
Yes, my
no
lord.
difficulty, but there is no question of court ordering him to deposit rupees 2 lakh or 3 lakh per month. There can't be any such condition.
No, I should have a security, my lord. This is not, right now it is 10 years is past.
Your suit is for possession?
Yes, declaration, possession.
No, when you filed the suit, you sought possession or during the pendency of,
Amendment.
during the pendency of the suit, you sought amendment of the prayer?
Yes, my lord.
Next.
Because they mention it to the court saying that they took a position when the suit was pending. Therefore, immediately
You filed an application for amendment.
amendment. That was allowed.
Then you have to deposit reasonable amount towards mean profit. May not be 2 lakhs or 3 lakhs. It's a vacant site, we understand.
I will take insertion notes. As it, notes, my insertion is a vacant.
Understood.
site.
Still, you would have earned something from it.
Lordship, may I have this matter Monday or Tuesday? Sir, I will take instructions and I will make my submissions.
Can we take up this for final disposal?
Yes, my lord. That is why I am requesting your honor. Direct decision on the judgment of Supreme Court.
What's the?
Record secured? Yes.
Okay.
When?
Tuesday, my lord. Tuesday, Monday, Tuesday, at your convenience, your lordship. It's going to be a landmark judgment, your lordship.
I think all judgments are landmark.
No, it's a fraudulent case. I'll place before your lordship. Fraud, how fraud has placed?
Not next Monday.
Please,
Thereafter.
Good.
Yes.
Good.
Till such time, they are not precipitate.
Your undertaking will continue till then?
Yes, my lord.
Undertaking given earlier will continue till next date.
Jai Nandan.
Appellant. For the respondent, plenty. Caveat that.
Lord, the appellant were the defendants in a suit for specific performance in OS number 1152 of 2011. My lord, the suit subject properties were 2 properties, one in survey number 2/1 and 2/5, measuring 35 guntas at Vartur Hobli, Bengaluru Rural. And survey number 30/1 and 31/1, measuring totally 1 acre, 8.5 guntas.
Original agreement substituted by subsequent agreement.
Subsequent agreement. I pleaded under novation of contract. However, the same was admitted by the respondents
Okay,
herein.
under the agreement, how much you are supposed to pay?
70 lakh rupees was
How much you paid?
I have paid 30 lakh rupees. That was admitted during the course of
What
cross-examination.
about balance?
The balance I had to make the payment for which I had issued the checks, which came to be bounced and
Deposit
check
them.
bounce cases came to be filed against me.
Deposit the amount.
I will-
Followed the suit.
You are saying that agreement is substituted and you are
Substituted
supposed to
by
pay
a-
70 lakhs. That is
Correct.
your defense.
Correct, that is my,
30 lakhs you have paid.
correct.
40 lakhs you must pay.
I will seek instruction, my lord, if it are.
Not agreeing for specific performance, nor agreeing to repay the amount as per the substituted agreement.
They have, my lord, my respectful submission is, they,
Then the agreement was substituted. There, we could repay 70 lakhs.
Mm.
Now, then we pay 30. Not paying 70. Not paying for specific. You can't have both ways.
correct. My lord, my respectful submission would be, they have not taken, they have not sought for a prayer, even though they knew about
No,
the
your
subsequent
entire
agreement.
defense is There is one more agreement where
there
you
is.
agreed to pay rupees 70 lakhs to
Exhibit
cancel
D.
the earlier agreement.
Exhibit D1.
You paid
Exhibit.
30 lakhs.
Yes, ma'am.
For remaining amount, you issued the check dishonored. You have
Yeah.
to pay the amount.
Yes, my lord, now the one difficulty, they have not
Unless you
sought
pay
for,
the amount, how can you oppose specific performance?
they have not sought for refund also, and that in that agreement, Exhibit D1, it is
Forget about
specifically.
technicalities. Forget about technicalities. You have received 30 lakhs from them.
From them.
That now you say that.
We
you to
have
pay.
paid the 30 lakh rupees at the time of, as per the original agreement, 35 lakh was the sale consideration amount.
Understood, sir.
2010, 31/10/2010, the Exhibit P1 agreement, the sale consideration was, my lord, 35 lakh. I have paid substantially 30 lakh rupees to the
The entire 35 lakh
plaintiffs.
rupees has been paid as on the date of execution of this agreement.
Sir, you issue a check pursuant to the agreement, check is dishonored.
Yes, sir.
Unless you deposit the amount.
I'll seek 2 days time, my lord. It's granted on Wednesday, I will
Deposit the amount, then
make
only
the
we can hear
submission.
you.
I'll make the submission.
So your entire defense is I'm liable to pay 70 lakhs, to put it another way. Entire defense is that I'm liable to pay 70 lakhs. Because the earlier
Exhibit-
agreement is
I
cancelled.
agree. I depend on the Exhibit D1 agreement, the memorandum of undertaking. I will,
Whether that
Where you agreed to
novation
repay
is
70
completed
lakhs.
or
my lord,
There you agreed to repay 70 lakhs.
my submission, my lord, is the originally, the pleadings of the party was that the Exhibit P1 agreement of sale was also not with respect to sale of our suit schedule project properties. It was with respect to a loan transaction under which the defendant number 2 was supposed to start a fuel unit.
this contention was not taken in the written statement, not taken in the
We will go
evidence.
by your
This is the
document.
first time they have
We will
taken
go
a
by your
contention.
document. We
Exhibit
agree with
D1.
you. We believe you. You agreed to pay 70 lakhs, pay 70 lakhs.
My lord,
Don't keep
for
this
which
stuff.
there is
and
no
moreover,
prayer.
the exhibit D1 is subject to payment of the full amount. If they fail to pay that amount, that earlier agreement will
Sir,
review.
once the check is dishonored,
Please.
you filed a complaint. So you give up your claim relating to specific performance. You are not ready to and willing to pay the balance consideration amount. You also give up your claim. That is the reason why we are insisting for him to pay 70 lakhs and to put a quietus.
Let them deposit, my lord.
I will seek
If he
instruction.
deposits, nothing to be heard.
My lord, will instruct, I will ask my senior.
I will seek instruction. 2 days time may be granted. I will seek instruction because it's a huge amount.
The more time you take deposit the balance amount, the stronger becomes his case for specific performance.
I will look into it.
Yes, learned. At the request of the learned counsel for the
Yeah,
appellant.
Thursday.
List
Madam, date,
22nd,
please.
Okay.
preliminary hearing, number 4,
That matter, my lord. So what I pray, my lord, whatever your lordships may decide, I don't think, my lord, the records will ever be, they had called, again, they called me, they said, see what you best you can do. And I am helpless, my lord. I don't want to do all that, my lord. If my conscience is clean, I do not want to manufacture documents. I want to come clean, and they are also asking me during that period if you can see some documents exist. I don't want to do. I want to suffer, my lord, if that is my fate. Whatever your lordships may, I leave it to my lord's thing. Because it will only delay I have health issues and I am suffering. Because of this only there is some health issue, and I am, my lord, almost chronic disease. So if this prolongs, then there will be uncertainty. Therefore, my lord, whatever your lordships to. Otherwise, my lord, if last chance is given, from my personal note, I am saying he is forcing, client is forcing, and let there be certainty.
What is the penalty imposed now?
4 consecutive four consecutive promotion increments are withheld, my lord, with cumulative effect.
What stage?
Lordships may say. Because even this should have been this should have been part of their charge sheet itself, my lord, that the proposal. My humble sorry.
My lord, only two submissions, my lord, if
Yes.
lordship permit. One is, my lord, that their work order should have been very accurate as to which building it pertains to. Then it leaves ambiguity is first question.
If nobody has copies of the work orders
Yes, they
of
are
the-
produced, my lord,
or
before your lordships.
whatever was the,
Originally, what was, now that your lordships will find, that only said hostel building in Davangere.
that we've seen.
Yes.
Agreement was also.
Agreement was not part of the, no, that was not part of,
The way he wanted to construct
Sorry?
is constructed in other building.
No,
Agreement says-
what, therefore, even in the inquiry, what was relevant was what exactly was the work order?
that was not part of the inquiry, my lord. In the,
Say that he is constructed in another building. Should it not come out in the inquiry as to what was the work order?
neither the inquiry nor, my lord, the,
Whether it is Saraswati layout or the other, he
No,
produced.
Hostel name is there. Hostel name is.
no. 124.
Two hostels are there, my lord. A different name.
Is why we are saying, what is the work order? Where was it supposed to be constructed?
May I persuade your lordships to see page 130, my lord, 130. That too, that name is, again, one more confusing name is used. Whereas 7, my lord, on 130, in the year 2009-10, 2 additional rooms were constructed in DGM hostel first floor. Again, see, my lord, how casual the inquiry is. This is not even BCM, not even this, DGM hostel. And my lord, they were constructed at the place of building existed were shown as one Basavarajappa, then extension officer so-and-so, who was in charge of DCM hostel also. The total cost of the building was 4.9 lakhs. In view of the urgency expressed by DCM, hostel authority again. DCM hostel, that's not DCM also. Now DGM and DCM both are wrong. Either it could be BCM, backward classes and minorities. Very casual approach. Hostel work was taken up on priority. Work was completed satisfactorily as per the sanctioned estimate, lordships may see. Upon receipt of complaint from executive engineer Lokayukta, inspected the building on so-and-so. As per the report, additional rooms have been constructed in BCM hostel. Again, that confusion, which as per the estimate and money has been properly utilized, lordships may see.
Into those records, give us details as to what was the work order. Is there any material in any of the records before the inquiry? If there is, please list it and give it to us, we'll consider.
Money has been properly utilized, as if it is an allegation
That
against me.
that we
money has been.
understand, but that
No,
is
no.
not, that was
No, my
not
lord.
the allegation against.
Even the hostel name, lordships may see in the inquiry report, I'll complete, my lord. In the inquiry report, the hostel name is spelled in 3 different ways. One is, my lord, DGM hostel, one is DCM hostel, then BCM hostel. In the inquiry report itself. So
Yes,
this is the
please
ambiguity.
Give it to us in the form of a written synopsis.
I'll do
We
that.
can
I
consider all
vote
3
on.
of you.
Please, grateful.
Please tell us what in the inquiry, what was the material in the inquiry to hold that he has constructed it
Please. Please.
please, in the form of a synopsis.
Please.
Within the week,
Please.
you want it listed again?
No, I think I will give that synopsis, my lord. Why again, same.
No, not for further arguments.
No, no,
Please just
I-
place the
Yes,
synopsis
madam.
on
Yes,
record. We'll
for
decide.
that limited.
Yes, we've heard it quite extensively. We
Yes.
are as of yet not unable to find anything which says on what material this was. You say that it was in another place.
Please.
Please place it on record. We'll,
Oblige.
yes, 23rd.
Grateful.
5.
I appear for the petitioner, my lord. This is the writ petition filed by the Income Tax Department, my lord. The respondent had joined the department as a tax assistant, my lord. Since she had not completed 3 years of service, she was not promoted to the post of inspector. However, junior of the respondent was promoted. Hence, she filed a representation claiming that she was also eligible to be promoted, my lord. Since there was no response given, she approached the Honorable Cat. The Honorable Cat, after listening the petition, allowed the petition, my lord. Subsequently, they filed contempt petition since we had not acted upon the order of the Honorable Cat. Then during the pendency of the contempt proceedings, we have granted her a promotion. We have granted her notional promotion, my lord. But still the contempt proceedings was not dropped because the respondent was claiming arrears in salary on notional promotion, my lord. Hence, we approached this honorable court by filing the writ petition. Though writ petition came to be dismissed, the honorable court gave us liberty to approach seeking clarification, my lord. We filed miscellaneous petition seeking clarification on consequential benefits. That miscellaneous petition came to be disposed of, directing the department to pay arrears in salary, my lord. Arrears in salary for notional promotion is not applicable, my lord. We have given her step up in pay, my lord. We have granted her step up in pay. We have fixed her pay. We have fixed her seniority, and we have given her financial upgradation under the ACP and MCAP scheme with effect from 18/1/2019, my lord. In spite of all this, she is claiming the Honorable CAT has directed us to pay consequential benefits, which includes arrears in salary and also benefits attached to the higher post, my lord. She has not discharged duties in the higher post at all, my lord. Hence,
Please tell us what was the reason for the delay in promoting her.
My lord, she had not completed 3 years, and hence we did not have the, we could not grant her promotion at all. We had to take the instructions from CBDT, my lord, which is the Central Board of Directors.
Why was the junior promoted?
My lord, she had already completed 3 years of service and cleared examination also, my lord.
What was the finding in the earlier round of?
The earlier round of writ petition, my lord?
Yes.
My lord will find it at
40, page 40.
1. Sorry, my lord.
If that is not the case, it is evident from the order, page 44. Persons who had given up their seniority by requesting transfer had been placed above the applicant.
My lord,
It was a mistake on your part.
No, my lord, this order
Because
is
it
not
was.
completely correct, my lord. My lord is right. That is the order. But here the respondent had not completed 3 years of service, my lord. Hence, we were not in a position to grant her promotion unless and until we received the specific instructions from CBDT, my lord.
What is the provision which says that the person has to complete 3 years of service?
My lord, it is promotional rules, my lord. I have not.
Yes.
My lord.
Now the question is simply this. Was it on account of some error committed by you that she was denied promotion? If it was, the consequential benefits should follow.
Yes, my
If
lord.
it is
Yes.
not.
I'm aware of that order. Yes, my lord.
Therefore, if you have to convince the court that it was not on account of any error on your part that the promotion was denied or delayed.
Yes, my lord.
Unless you can substantiate that.
Yes, my lord. I have reduced all that in my
Interfere.
petition also, my lord. Simple reason why she was not
Where is it?
granted promotion was,
Counsel, where do you say so?
my lord, that order I have not produced here, my lord. Mainly, I am before this honorable court only to substantiate that in the in notional promotion, by way of consequential benefits, we will not pay arrears in salary, my lord, because she has not discharged duties of the higher post.
That by itself will not do. If you were at fault in denying or delaying the.
Yes, my lord, I understood it.
Please
I may
make
yes.
available the material so that
Yes,
we
ma'am.
can consider properly. Let them also come on record.
Yes, my lord. I have-
Yes, issue notice, the learned counsel appearing for the petitioner seeks time to produce all relevant material in support of their contentions. List immediately after service is complete.
Yes, my lord. Much obliged.
For the petitioners, my lords. Not the petitioners were the deputy range forest officers, my lords. Earlier, my lords, they were promoted, my lord, they were placed under Rule 32 of the KCS rules, my lords, in an independent charge during the year 2013-14. Till, my lord, 2021-22, my lords, they have not been promoted, nor, my lord, they were placed, my lord, under Rule 42B. Therefore, my lords, they made representation questioning their seniority list as well as my lords not giving the promotion, and ultimately landed before the Honorable Karnataka State Administrative Tribunal, in which my lord there was a direction directing the response to consider their representation and put them in proper place. Then my lords, subsequently my lord, an order came to be issued void annexure A22. Void annexure A22 my lords.
Yes.
My lord, placing them my lords, promoting them my lord, with effect from my lord, 10/12/2021 my lords. It is my lord annexure A21 my lords, page number 221, of course my lord, it is in Kannada. That's the 10/12/2021 was the date my lords given not for their promotion, though the date of order is 22/7/2022. Lord, our request was my lords, they were required to be promoted since from the date my lords when they were promoted, my lord, they were placed in an independent charge under Rule 32 by considering their service records. Then my lords, a further corrigendum was issued my lord, on the next week, my lords, 28/7/2022, saying that it is their promotion is not from the date of 10/12/2021, but from the date of passing the order, that is on 22/7/2022. Those two orders were questioned by the petitioners my lords before the Karnataka Administrative Tribunal. Void annexure my lords, see my lords, the tribunal passed an order partially allowing the application, but while quashing the orders annexure A22 and 23 my lords, 21 and 22, held that they are not eligible to be promoted retrospectively, but from the date of order. That is my lords agreed my lords by the petitioners, because they were placed my lords in an independent charge, though Rule 2032. They are eligible.
Is there a quota provided for this post? Is there a quota provided?
Not quota was provided. Quota was provided. That is why not their service records were summoned. And not what the tribunal says, it was not placed before DPC, and in the sense not Department of Promotional Committee has not been considered their request. And moreover, the finding of the tribunal notes.
Yes.
Kindly see notes page number 281, internal page number 14 of the order of the operative portion. The direct page number 281 minutes.
Yes.
In the discussions about the applications partly succeeds, and we summarize our conclusions.
What is the right which flows out of a provisional promotion?
Once they
Even if it is an independent charge.
Yes.
What is the right? If it is
what the tribunal says, it is ad hoc post.
Yes.
That is why the tribunal holds that they are not eligible, entitled.
It does not have to be, the post does not have to be ad hoc.
Please.
If the appointment is under Rule 32,
yes,
it's only a temporary arrangement till the.
For 6 months, my lords.
Therefore,
for 6 months.
What is the right which flows out of such a promotion?
Lord, as a matter of fact, when they are placed under an independent charge, they are equal, my lords, eligible to be promoted from that date, my lords. Moment the 6 month is elapsed, my lords.
There is no such provision. Yes. Which are the rules?
Rule 2(3) of the Karnataka Civil Service, PP3, rules 1928. One minute, sir.
Because if it is a selection, if it is a promotion which has to be done on the basis of a DPC recommendation, the fact that they had.
Basic independent charge also, they hold it for DPC and place them.
Even if the first selection is without holding a DPC.
Normal. Rule 2, 1 provides retrospective. 3, when it is not.
If while being eligible according to his seniority in the list that was enforced, and otherwise fit for promotion according to cadre and recruitment rule. There again, this quota has to be operated. He had only been placed in independent charge of the post and has discharged duties.
Retrospective promotion is a provision.
Yes.
I seek instruction.
Yes.
First time.
Yes, learned government advocate takes notice on behalf of respondent, seeks time to get instructions. List after 2 weeks.
Please.
Seven,
For the respondent.
For the petitioner.
Kailash T.
Great place, Lord.
Yes,
Yes. The matter is posted today for my learned friends instructions.
yes, just a moment.
Lordship may direct us to consider and remand the matter without going into the merits, and
We will
it
not.
should not be treated as precedent.
Yes,
Keeping all
Yes.
the contentions open, my lord, all the.
yes. We leave all the contentions open and remand it to the respondents to take a decision,
Yes.
First
taking note of all the available material. You can also produce anything that you lay your hands on.
Sure.
Yes.
Annex A19 series are the set of representations we have submitted.
Sorry?
Annex A19 series are the representations options we have submitted. On which
A19 are the options based on
Yeah.
A18.
A18. Yes, ma'am.
Let the
Everything,
first respondent consider.
yes. R1 will consider. What
Yes,
time?
Yes.
Within what time?
Within
Months.
3 months.
3 months?
Yes, ma'am. Yes, ma'am.
We've heard the learned counsel appearing on either side. We've also heard the learned DST appearing on behalf of respondents 1 to 3. It is submitted by the learned counsel for the petitioner that the
Let that be the order of the court.
yes, of course. It is submitted by the learned counsel for the petitioner that the petitioners were entitled to a consideration of their claim for being governed by the old pension rules in view of the fact that their services had been regularized consequent on the on a scheme for absorption and regularization. Full stop. It is submitted that the proposal for the applicant's absorption and regularization was well before 1/1/2004. And the scheme based on which they were appointed was also prior to the said date, when the National Pension Scheme was made applicable to the employees of the department. It is further contended that it was against vacancies which were in existence long prior to 1/1/2004 that the petitioners had been regularized. Full stop. It is submitted that in the light of these facts, the petitioners were entitled to a consideration of their claim for being covered by the old pension scheme. It is submitted by the, it is further submitted by the learned counsel for the petitioner that the tribunal had held that the date of absorption being subsequent to the to 1/1/2004, the said claim with regard to coverage under the old pension scheme could not have been raised by the petitioners. The learned counsel for the petitioner would further contend that on the strength of Annexure A18 of his memorandum dated 3rd March 2023, which specifically provided that in all cases where the employee is appointed against a post or vacancy, which is advertised stroke notified for recruitment prior to the date of notification of the national pension system, and where the vacancies were in existence before such date, the employees would be granted an option to be governed by the old pension scheme or the national pension system. It is submitted that pursuant to the said official memorandum, Annexure A19 series of options had been filed by the petitioners. And the said options are liable to be considered taking note of the vacancies against which the petitioners were absorbed stroke regularized, as also the scheme under which they were so regularized. Full stop. It is submitted that this aspect requires a consideration at the hands of the first respondent. Having heard the learned DSG appearing for the respondents also, and after considering the contentions raised on behalf of the respondents as well, we are of the opinion that the said request is a reasonable one, and the claim of the petitioners requires a consideration, specifically adverting to the scheme under which they were appointed and the vacancies against which the petitioners were appointed. In view of the specific contention raised that the process for recruitment stroke regularization, not recruitment, absorption stroke regularization had been initiated before 1/1/2004. The first respondent shall take an informed decision on the request made by the petitioners at Annexure A19 options in strictly in terms of Annexure A18 of his memorandum. There will accordingly be a direction to the first respondent to take up Annexure A19 series of options and consider and pass appropriate orders on the same in the light of Annexure A18 OM. The petitioners are free to produce any relevant material before the first respondent to aid the consideration of Annexure A19 series of options. Appropriate order shall be passed after considering the contentions. Hearing not required.
All the contentions.
After
All the
considering all the
contentions are left
contentions, which shall be placed before the first respondent, order shall be passed within a period of 3 months from date of receipt of the copy.
All the contentions are left open. and
All
it shall-
contentions of the parties are left open.
And it
of
will
the-
not be treated as precedent.
Of the parties are left open to be decided at the request of the learned DSG. This judgment shall not be treated as a precedent in any further matters.
Great.
Yes, much.
Yes.
Great.
Eight. To Prasad Chantandur.
That's appearing for the petitioner. My apologies, matter was moved. However, due to ill health of senior since morning, he could not appear. My request for Monday, my lords.
Yes.
Not Monday. Not Monday. Monday is a no service day.
Tuesday, my lords. Emergency then.
Tuesday, Thursday. Because Tuesday we have quite a few.
Challenge is
matters
only to the
listed.
articles of charges.
18th.
Much.
At the request of the learned council.
9, Vijay Kumar.
For the caveator in this case.
No.
Not.
Lashib, senior has got some inconvenience.
For
because of
preliminary
some
hearing,
family, wedding. He could not come. It may be kindly listed on Monday or Tuesday.
Preliminary hearing for IA. What is the prayer in the IA?
Not I've sought first.
You see,
Dispensation.
this is all.
Not the issue is like this, my lord. Not the petitioner was on deputation too. Not the.
Stay the operation of the impugned order.
Lord, can I make a submission? Actually, this is the third round of litigation what's going on.
Hmm.
And
But how it is the
I
third
was the
round of-
caveator. They have served the copy day before yesterday. I have given the copy to Rajendra Kumar sir. So he has to come. So we are asking time until Tuesday, Monday, Tuesday, any day. Because he's in family wedding.
Next week.
Date may be given.
Next week. Yes, please give a date.
Much obliged.
Next Tuesday, not the coming Tuesday, the Tuesday after.
24th.
Much obliged.
24th.
But next week, sometime next week, my lord.
May not be possible. Was the number
For
of,
interim order, my lord, the way the order of the tribunal, my lord, it says that I have produced, my lord, what has happened was, my lord, I was, the fourth respondent was placed on in charge basis in my place, my lord, though I was senior to him. My lord, the issue is, my lord, she approaches this honorable court, my lord, instead of going to KAT. My lord, she withdraws the writ petition on 26/2 and files an application on 27/2. Enclosing a copy of the status report of the High Court showing that the writ petition is dismissed. Now my application is dismissed on the ground that the writ petition is still pending in the High Court. This is the issue, my lord.
list on someday? Yes.
18.
Please.
Hearing on IA, number 10, AM Prakash.
Application for vacating the stay.
Selection, second division assistant lords had heard
Who
this.
appears?
Counsel for KPSC. KPSC, Shri K.M. Prakash.
Where is the KPSC? PDC or +2, computer knowledge, diploma or other will not be considered. JOC.
JF equivalence. The other day it was.
Government has not declared
Pass over, ma'am.
equivalence.
My lord, I have examined all the case laws, my lord, on the question of estoppel against an unsuccessful candidate who challenges the selection process after being declared as unsuccessful. I've gone through all the decisions, my lord. It is attained the status of stare decisis, my lord. And the only exception contemplated is
We consider.
if there is
Pass
any
over.
legal. I have all the decisions.
Pass over.
I've summed up all.
Apologies, seal number 8. On the 18th, there is some inconvenience. There is a special bench constituted. May I request for 19th?
Yes.
11, government advocate.
For early hearing.
But this is a matter which where the Supreme Court has rendered a split decision. In fact, the tribunal has relied on Gijroya's case, my lord, where the last date for filing the caste caste certificate of an OBC candidate had to be obtained prior to the last date for selection. In this case, I think there is a delay of 2 days, not more than.
There is a, I
It-
applied
now-
for the caste certificate, my lord, on 4/7/2017. But I'll give only 2 dates, my lord.
Hmm.
My lord, employment notification
Hmm.
is dated 26/2017.
26.
26,
Hmm.
20th
Hmm.
June
When was
2017.
the last date?
Lord,
Prescribed
the submission of application commences from 27/6.
Hmm.
Lord, last date for submitting the application is 26/7.
Hmm.
Lord, I applied for caste certificate on 4/7/2017. They did not give, my lord, the certificate on time. They issued the caste certificate on 28/7. I, my lord, given the certificate on the same day.
Hmm.
2 days delay, my lord. I was working in the, my lord, government.
2 days is not the issue. Question is whether it has to be given on the last date or
That is
before the at the time of verification.
I have
That is
given,
only this.
I have given.
That is the prescription is it should be obtained prior to within 5 years from the last date for submission of applications or before the within a period of 5 years from the
Prior
last date
to
of
the,
and prior to the last date of
But I have
is
applied,
the
my lord, on 4/7.
and the tribunal relies on Gijroya's case. My lord, now there is a split decision on this very issue. I've referred to this decision on the last occasion, my lord.
No, delays on your part. You did not give it in time.
My lord, they had times for 5 years. They have to obtain a certificate in anticipation of applying for a government post, my lord. They have 5 years time. So it should have been obtained any time during the 5 years preceding the notification.
He applied on 4/7. 26/7 was the last date.
My lord, they have 5 years time, my lord. It's not as though they can, my lord, then everybody will raise this objection. They have, my lord, sometimes law is based on expediency and not, it may not serve the purpose of justice sometimes, my lord. Otherwise, it may not be practicable to run the administration.
But what the clause says is, I am required to
At
take,
page 77 is the,
what is the clause?
not
page
page
77.
77.
It's, but the
Not
translation is
translation is
not
also
very
there.
good, my lord. The translation is at page
99, my lord. My lord, may I read the
Yes,
translation?
please read the original. Please read the original.
ಅರ್ಜಿ ಸಲ್ಲಿಸಲು at page 77,
Hmm.
middle of the page, my lord.
Hmm.
After the bullet points.
Yes.
In the middle of ಅರ್ಜಿ ಸಲ್ಲಿಸಲು ನಿಗದಿಪಡಿಸಿದ ಕೊನೆಯ ದಿನಾಂಕದಂದು ಚಾಲ್ತಿಯಲ್ಲಿರುವ ಮೀಸಲಾತಿ ಪ್ರಮಾಣ ಪತ್ರವನ್ನು ಸಂಬಂಧಿಸಿದ ತಹಸೀಲ್ದಾರ್ ಅವರಿಂದ ಪಡೆದುಕೊಂಡಿರತಕ್ಕದ್ದು. ಹಿಂದುಳಿದ ವರ್ಗದ ಪ್ರವರ್ಗ 2A, ಪ್ರವರ್ಗ 2B, ಪ್ರವರ್ಗ 3A ಮತ್ತು ಪ್ರವರ್ಗ 3B ವರ್ಗದ ಮೀಸಲಾತಿ ಪ್ರಮಾಣ ಪತ್ರಗಳನ್ನು ಪಡೆದ ದಿನಾಂಕದಿಂದ ಅರ್ಜಿಗಳನ್ನು ಸಲ್ಲಿಸಲು ನಿಗದಿಪಡಿಸಿದ ಕೊನೆಯ ದಿನಾಂಕದವರೆಗೆ 5 ವರ್ಷಗಳ ಅವಧಿಯೊಳಗಿರಬೇಕು. ಮೂಲ ದಾಖಲಾತಿ ಪರಿಶೀಲನಾ ಸಮಯದಲ್ಲಿ ತಪ್ಪದೆ ಹಾಜರುಪಡಿಸತಕ್ಕದ್ದು. ಅರ್ಜಿ ಸಲ್ಲಿಸಲು ನಿಗದಿಪಡಿಸಿದ ಕೊನೆಯ ದಿನಾಂಕದ ನಂತರ ಪಡೆದ ಪ್ರಮಾಣ ಪತ್ರಗಳನ್ನು ಪರಿಗಣಿಸುವುದಿಲ್ಲ. So anything obtained, even that is stated, my lord. Anything obtained after the last date will not be considered. And it is, my lord, it is highlighted also, that part. It should be obtained within any time, within 5 years from the last date for submission of the application. Lord, because this is a OBC reservation, the income criteria also applies because they will be eliminated on the basis of creamy layer.
Non-creamy
So
layer.
now the matter is before the full bench of the Honorable Supreme Court because there was a split decision in Sakshi Arha's case, my lord, which was in 2023.
Bench of the High Court erred in not considering the decision rendered in Pushpa's government. Considering both sides, which was referred to much prior to date of advertisement. The office of the competent authority took considerable time to make the required OBC certificate available. It was in such circumstances, the learned civil judge of Delhi High Court held that the applicant cannot be made to suffer for the lapse on the part of the SDM office in issuing the OBC certificate. The Borough Sharma reported in so this is to the view expressed. Gijroya has only been doubted and referred.
Yes.
It will not take away the precedential value of Gijroya. It is still binding on all courts and tribunals.
Indeed, my lord, that's correct. But the matter has been now referred to the.
It has now been referred. But in the meanwhile, can we say that we will not follow because it has been doubted?
It can't be said so.
Open to us to say so.
But it's a case where, my lord, I was working as, my lord, staff nurse on contract basis for the last 11 years. Lord, age relaxation is provided under the rules. They have extended the age relaxation. Lord, I have claimed reservation under 2B. Lord, I have applied, I have submitted my application on 6/7/2017. I have claimed reservation. Lord, in view of the law laid down in my lord Charles' case, Lord, if I have claimed reservation, Lord, proof of claiming such reservation can be supplied later. Lord, what is material is, Lord, whether I have claimed reservation under 2B or not. I have claimed reservation at the time of, my lord, submission of application.
That
Lord,
applies to a case where income is not a criteria. That is what is pointed out in Gijroya's case. Because income is a dynamic criteria. It changes. That is the reason it was referred to the larger bench.
Lord, I have claimed and I have
I
applied.
had brought
on
this to the
4/7.
attention of the court on the last occasion, my lord. My lord, this honorable court was pleased to defer the matter subject to the, my lord, may I just pass on this decision, my lord. Paragraph 58 is the, sorry, my lord, I don't have stock of it. 58 of Sakshi Arha case, my lord, where they point out the difference between OBC reservation, which is subject to creamy layer, and SC/ST reservation, which is where no such
This very rare.
All the applicants have to be issued after the last date for their submission. March later. Very good. Last date was 5 PM and 21.
Most,
Yeah, later.
yeah. This also limited recommendation and means. It being after for the education. It page. Any education. People failed of past it.
Point correct. It has to be, you say it to the certificate must be obtained. The application is going. The video is on the phone call. And the people make a distinction saying that to say that it is obtained before may not be there. That was what is applied before will not mean it failed. It's that appears to be the word. But this is something which is obtained after 2 years.
This one and which one?
Plus, here is the point. In Sakshiyara, all the appellants had produced their respective certificates which were obtained by them after the last date fixed for submission of the application. It is not it is not a case where the application had been made well before and there was delay on the part and the application was, the certificate was issued only 1 day or 2 days after the last date. Here is a case where all of them had applied after the last date and the certificates were dated 1 year after the last date. Then they produce it. Therefore, it is said that it is correct. The question
Also, this honorable court has also distinguished, my lord, Gijroya's case.
Hmm.
Lord, I'm just, can this be taken upon another day, my lord? I'll present the other judgment where this honorable court has also distinguished in a similar case.
Are you referring to 13449?
103063 of 2021, my lord. It's a 2022 decision, my lord. It's a reported decision. I'll learn it when just pointed it out.
Yes, please make the judgments available, we'll consider.
Please.
Because this, just because it is referred may not be,
Indeed.
and the facts also appear to be different.
And this honorable
Sakshiyara
court can
take
take, distinguish Gijroya's case. Lord, if it is appropriate, if your lordship sees
Not
fit.
aware of, not date of reference, not in Karan Singh Yadav, not the full bench, not the 3 judges bench.
2023.
Huh?
2023.
Karan Singh Yadav is here.
Karan Singh Yadav,
It's clear.
not referring, not Ram Kumar Gijroy,
Hmm.
says that not proof supplied later, if it is claimed, not if my lords are holding my Lord Karan Singh Yadav,
Karan Singh Yadav, the order dated,
28 September 2022.
oh, this, it has been answered.
Yes.
This is the reference.
No, that has Sakshi. Adalla, 2022.
Leave granted appeal challenges judgment order so and so. We have concerned with process of selection. Challenge raised with such rejection did not meet with any success. High Court by order presently the challenge rejected the petition immediately. Identical fact situation came up for consideration before this court. Therein this court ruled in favor of the complaint. Still matter is thus completely covered. As we noted that as a result of cancellation of candidate, the appellant was never appointed to the question president will not be to grant any substantial relief, therefore appeal is disposed of with no rest. This is a three-judge bench.
Yes.
After the reference. The reference you had handed over is dated 24/1/2020. Has been,
have a look at.
that appears to have been answered. It is not answered. It is stated that the issues covered by Ram Kumar Gijoria.
I just have a look.
That is my Lord, three-judge bench.
That is the end of the reference. Therefore, let us see.
The question that arises for consideration is in the matter of OBC reservation, the income criteria which
Income
applies.
criteria applies when an application is preferred on 4/7 and you sit on it and you grant it
But they-
after the
I-
last date.
There is also fault on the part of the applicant in that they did not obtain it within 5 years of the last.
That we'll consider.
Not a- and-
Yes,
and-
please make available the judgments you are relying on as well. When?
And my Lord, in respect of very same selection,
Hmm.
with respect to staff nurse,
Hmm.
Lord, by order dated 19/7/2022, my Lord, coordinate bench of the Honorable Court
Hmm.
has held
Hmm.
that, my Lord, if I have claimed reservation,
Hmm.
that would suffice.
Which is that?
Lord, it is thereafter, my Lord, reference has taken place, my Lord. In
Let's hear this on the bench.
Court of
Application, I mean, it is, it has to be within 5 years from the date of. Correct.
So the notification of 1 month, it will be less by 1 month for 5 years.
That is not the language. The language is it must be one obtained within 5 years from the last date. And it must be obtained before the last. 5 years counted back from the last
Older
date.
than 5 years, not valid.
No,
After the
older
last
than
date,
5 years
it is
will
not
not.
valid.
That is it. And after the last date also will go. That will
Lord,
not. If you,
Lord, in the
if you make an application and keep it, I mean, if you have a caste certificate, keep it with you, you can use it for 5 years in whichever selections come. But when you make when the notification comes, you make an application, you expect some kind of speed with which it has to be done.
Not a new criteria, my lord. It's been there since very long, and the candidates are aware that
Yes, non-creamy layer certificate, non-creamy layer certificate again, if you take it and keep it with you, also, you won't accept it later than a particular point. In some cases, it is 3 years. In some cases, it is 5 years.
5 years.
They make an application, you must do it within a reasonable time. Otherwise, in every case where an application is made, they have to come before this court. There are several cases where.
another important major law in the application before the tribunal suffers from non-joinder of the necessary party. They have not included the party who will be ousted by the inclusion of the petitioner.
At the stage of selection, there is no question of any ouster.
But somebody is selected now. That person will be ousted. He has no.
When was the OA filed? At a stage where the ouster is.
No, after the selection was complete. Selection list was announced. The final select list has been challenged. So non-joinder is a serious flaw.
We'll
Because that
consider
person will be affected without notice.
My lord, there, my lord, my contention is, my lord, posts are lying vacant. 889 posts were, my lord, notified, and 881 persons were selected. Posts were lying vacant. My lord, the Honorable Tribunal, while allowing the application, says that create supernumerary post if
Posts are not available.
posts are not available.
The extraordinary will be granted.
Yes.
Lord, in respect of, my lord, the very same selection, there, my lord, it was experience certificate.
Yes.
Not the service weightage of 10 years will be given under the notification. Experience certificate was not, was attached along with the application. However, in the column, whether you claim experience against that, the petitioner therein had applied no.
That was allowed.
That is, however, along with the
Now, it has been brought to the notice of the candidate long ago that.
That we'll consider.
Like I said, expediency sometimes plays an important role, not sometimes.
But I would say that, it is a curable defect. Not as held.
They did not come before the court. Yes,
They followed the rules.
we'll consider. Yes. When?
In view of, Karan Singh Yadav, judgment,
If that is the end of it, if that is the end of the reference, then this will have to be, yes.
But I'm also told that the case has been distinguished. Vijay's case, it has been upheld by the three-judge bench. That has been distinguished by a bench of this Honorable.
How can it be distinguished by?
Because
Okay,
on that particular issue, question of the.
Is it in respect?
Criteria being dynamic criteria.
Therefore, in that background, we think that
I'll
it
place
is,
it on.
yes. Yes. Next week.
Tuesday or Wednesday, this is the short point.
No. Next week may not be
Next
possible.
Friday.
Have it on Tuesday next. The Tuesday next. Yes.
23rd.
24th. Mukanappa has been.
Council for respond. Short question is, Madam. While promulgating the rules under Karnataka Civil Service Act, under section 3 and 8, previous publication of 15 days is necessary or not?
A draft has to be
Yes.
published initially.
That's all the question. Court answered it, yes.
Yes.
Though there is a split decision, review is filed. Ultimately, court said, since section 3 mandates that with previous 15 days is necessary.
Found to be mandatory. Found to be mandatory.
Yes, rule itself says.
Which is a section in the
Section
act?
3 of the Karnataka Civil Service Act. That is section 8. But every time, Lord, they take time, Lord, I have no objection. But the difficulty, contempt is filed. Lord, contempt is dropped today. On the Lord, it is pending before this court, contempt is dropped. For the last, Lord, 3 years, Lord, it has happened like 21 orders. Now they are promoting, Lord, based on the, Lord, the rule. They are subject to the result of the interpretation, we promote them. But I have.
I'm sorry?
My lord.
When?
Because he is appearing before the tribunal, yeah. And it is expected to go on.
He appeared in contempt matter.
Some other contempt matter.
Lord, I request you, Lord, to pass an interim order, not to promote anybody, but on the basis of the rule, that's all. Which is quashed. my application is filed by these respondents. Not now, in the note sheet they noted, it is pending. Subject to that, we consider promotion of the deputy director based on the rule, which is not already declared unconstitutional. There's no stay. In the contempt, they say you, if it is pending, take time.
When was the petition filed?
23. October 23. The rupee number 22841 of it.
Everything, of course, will be subject. If we find that this is the draft publication was mandatory, then all promotions made on the basis of the list will have to be entirely reviewed.
Please.
Is it not better that you don't make those promotions?
Lord, I don't have much instructions in this matter.
I may make one submission in this matter. Because the promotion to the cadre of deputy directors has already been done in the pendency of the application.
itself.
Yes. Therefore, no further promotion has been effected as such. As far as I am concerned, I am ready. Because state also has filed the petition challenging the order. And because since what had happened was, since we are not made as a party to the proceeding, then I filed a review petition. My review petition came rejected. I also
If
challenged.
the question is with regard to the to whether a draft is required or not, then it is for the state to answer.
Yes, that's the reason why. State has to answer, my lord. That's
State
why.
also filed a review petition. Review is dismissed.
Well, what had happened was, my lord, prior to the
These the on the in the week after that.
But they are effecting promotion from the cadre of deputy director to joint director. No.
We list it on the 30th. Whatever happens, if ultimately it is a mandatory requirement, then the entire rules goes. It will have to be redone. The entire promotions will have to be redone.
The rules section itself mandate.
Exactly. Which is why we are saying, if that is so, then it's only a matter of redoing it. 30th. We list it on the 30th.
Please.
May I still drive status quo as on today we will maintain. Because again, not multiple litigation. If they are promoted to joint director, they are doing it.
Further promotions on the basis of.
As my information, my lord,
They are
no
the
further
beneficiary,
promotion.
Lord. They are the beneficiary.
No steps has been taken giving further promotion.
Lord,
since
may I
late
just get instructions and make my submission?
We have
Can it
filed
be
in not already.
on his
on,
legs, my lord? I'll ask my friend to go and
8th
get
July.
instructions.
Respondent.
If I can give an
5th July.
undertaking that
2:30.
2:30. Grateful,
It's all right. 2:30.
grateful, ma'am.
Yes, only on this question, whether it can be held up till then.
Please.
I am for the petitioner. Yes, my lord. In this case, my lord, I challenge Annexure A, page 27. Order passed by the KAT summarily dismissing the application on technical ground, my lord, without looking into the merit. That order may be kindly seen, my lord.
Yes.
Okay. My lord, I have been appointed as a for the post of lecturer, my lord.
Yes.
Physics subject on 23/3/2000 applied, and I was appointed and on 8/7/2021.
Yes.
After lapse of 2 years, 1 month, a revised list has been made.
Yes.
I will take a lordship to the page Annexure Q, page 108. It is in Kannada, my lord, but content is in English, my lord.
Revised final list on 30/9/2023.
Yes, after 2 years, 1 month. And as per Annexure R, page 111, name of the respondent number 5 can be seen at page 112. who is the contesting respondent number 5 here in matter. Savitri Kambar, etc. matter. Now, this was challenged. In this revised list, my name was left out. I immediately approached the Honorable Tribunal, my lord, by filing an application. That was dismissed on 2 grounds, my lord. Non-jointer of the necessary parties at admission only. That may be seen at page para 3-4, my lord. Findings. Not on merit. That's at page 31, the first para, in that last 5 lines, my lord. We have already held that prayer for the quashing of the impugned select list in its entirety will require the pleading of all the persons who are part of the select list and not just the few in the said list, select list, who are arrayed as the private respondents 5 and 6 herein. In view of the discussions above, we are of the considered view that application is not tenable on account of joinder of necessary parties with regard to the prayers sought in the application. Also, the applicant has not sought for the prayer with regard to her selection in the impugned selection list and how she is entitled to included in the impugned selection list. Viewed in this manner, it cannot be said that the applicant is prejudiced in any manner whatsoever, since the applicant has not made out any prayer that she ought to be included in the impugned selection list, and the extent of her non-inclusion of the selection list is erroneous. The contention of the learned counsel for the applicant that prayer for the quashing of the impugned selection list by itself serves the interest of the applicant, since the select list for the basis of which she has been selected and appointed to service would stand revived on quashing the impugned select list is untenable under law, since the select list under which she has been selected is suppressed by the impugned select list, and the earlier select list do not revive automatically on the quashing of the impugned select list. Thus, the absence of the applicant justifying her inclusion in the impugned selection list by appreciating the pleadings in the appreciation and prayer for her inclusion is said to be impugned selection list in terms of merit with due regard to the reservation. The applicant cannot be said to be prejudiced by any manner. This is the order. My specific order is that
what is your prayer? What is your prayer?
Yes, madam. Prayer is to
for the tribunal.
Yes, madam. Quash the selection list, madam. That is revised selection list. And who are in the 2A post, that only I sought, madam. At the most, court would have been modified the order saying that insofar as the respondent number 4 and 5, madam.
This for you to make
Yes,
the
yes,
proper
madam.
prayers.
Yeah, yes, madam. I'm not on that, madam. But what I'm telling on that
Pray for the selection of the revised additional selection list.
Yes, madam.
You pray for the
Quash of the
quashing
entire list,
revised
madam.
final select list.
Yes, madam.
And the revised additional select list.
Yes, madam.
As the same is illegal, unjust, capricious, arbitrary, irrational, etc., etc.
Yes, madam.
Well, there's absolutely nothing wrong with what the tribunal said. Yes, what was your contention with regard to the your inclusion in the list?
Yes, sir. I was included. The KPSC selected me. I have been appointed, and I have still working for last 3 years. After a lapse of 2 years, 1 month, without there being a provision for revising a list, they have revised the list as per Annexure Q and on 39/2023, my lord. Now, KPSC has to say why they have revised the list after 2 years, 1 month. And why they have left out me from that list.
That you are sticking to your prayers. All the persons included in the list are necessary.
No, I'm sticking to my lord. My appointment shall not be disturbed. That's all, my lord. I giving appointment to respondent. Yes, my lord.
Your prayer is.
Yes, my lord. Yes, my lord. I understand, my lord. Yes, my lord. My prayer before this honorable court, I restrict.
Now we have to start an inquiry as to why the list was.
Yes, ma'am. That KPSC has to say, madam.
I'm applying for KPSC in this matter. Because on final selection list was done on 11/5/2020 as the matter of records. I cannot make any changes in the circumstances. Lords, the appointing authority, the second respondent has sent the Form 7 for the 2 vacancy posts, my lords. One is for the GMW and one is for the rural candidate in Hyderabad Academy. While seeing the list of the final selection list, There was an inadvertent mistake by the KPSC, my lords. What has happened, I need to submit it. So there was, petitioner was a meritorious, my lords. Her marks was 139, where the higher candidate who has scored 150 was been left out in the list, my lords. So while doing the revised list, we have done the revised selection list, my
What is the provision with regard to revision of a selection list?
lords, as such,
Under the-
once the list has been done, my lords, in many of the cases, we'll do our submission that it is become functus officio. But in this, my lords, since there was a mistake in the list, the less meritorious candidate was selected in final selection list, my lords. The KPSC has done the revised list, my lords, since the less meritorious candidate should not be.
You
fit
came to
into
know,
the-
how you came to know?
Lords, by looking to it, we have came to know to the bus of the secretary. Other than that, I cannot, my
That
lords,
time,
my
was there
hands
any
are.
objection by other candidate?
No, my lords, we have received Form 7 by the appointing authority for the vacant.
Have they been put on notice? Persons who found a place
It was
in
only the petitioner, my lords, where we have issued an endorsement.
Exactly.
It's not been. my
A
lords.
person who has found a place in the list and has been appointed. Has that person been put on notice, heard before?
That is the petitioner, my lords.
That has been
No,
done.
madam. No,
That
not
is
heard,
no-
madam.
that we have revised selection list and we have sent it to the appointing authority, my lord. This is, now it's before the government. And without any consideration of any of the representations, we have noticed our mistake, my lords. We have done this. My lords, have
In the rules of procedure of the PSC, habitually, there would be a provision which says that if there is
my lords,
any error,
once the list is been done, once it is sent to the appointing
even if
authority.
there is an appointment done. I'm only speaking from
The cases which were, please, my lords, there.
in, at least in the Kerala Public Service Commission rules of procedure, there's a specific provision. And in the general rules,
Please,
the state and subordinate rules also, there is a provision which says that if there is an error committed within a period of 3 years, it can be corrected and a notice has to be issued. The error can be corrected and the
less meritorious candidate will.
appointment can be revised. But it
Lords,
cannot
in-
be exercised out of time. Therefore, there is a provision which permits such corrections in both in the rules of procedure as well as in the general rules. Is there any such provision here?
I'll have spoken to the
Without
secretary.
such a provision, how can you say that we went wrong, therefore we are correcting? No, not after 1 month. She joins on 8/7/2021. 59/2023 is the revision. What is the provision which permits this revision?
My lords, more,
that
being
my
more
lords.
meritorious now, my lords, I have my fundamental right.
Then why is the,
Provisional list was released in the month of, during the time of
what
Corona.
is your fundamental right to be appointed
Lords.
from a list in the first place?
My lords, provisional list was done during the month of Corona and I did not have an opportunity to file objection.
Where did you file your objection after the final list?
I was, soon after the list was released, then I got to know that I am more
When
meritorious.
did you make a?
No, there is no such,
Correct.
there is no such representation. from
Therefore, it
the-
is not a question of your right.
But I am
It is
found more
it is a
meritorious.
question of power in the PSC to revise the list.
My lords, on that, I'll seek instructions and I'll make my submission in the next date. I'll put it in writing, my lords, what and what way we are.
I will
Yes,
look into.
you can also place any pleadings you want to place on record. Because
madam.
it has to be considered on the basis of the rules in force. Is there a power for the PSC to revise a finalized list from which appointments have already been made?
Latest
If there is
Supreme
a
Court
power,
judgment
we'll
says, my lord,
definitely
latest
look
Supreme
into
Court
it.
judgment, latest Supreme Court judgment says within 6 months, that's the only you can do. That's in the Bharati case, state of Karnataka versus Bharati, maximum 6 months.
If there is no provision.
No, yes, madam.
There is no provision. Because in Kerala, there is a 3-year gap. There is a provision. And within 3 years.
Government Rule 16 ಅಲ್ಲ ಇದು?
Within 3 years, they get provision of appointments being there.
Not particular, but just Rule 16 or something, general recruitment.
Yes, please produce the
I'll-
materials
please,
also.
Manoj, I'll-
Whatever it is that you are relying on what material you suddenly came to know that
Please,
the
Manoj,
mistake. Please
I'll
produce
place
all
it
that
before the,
material.
I'll place it before Lord.
Yes, learned counsel for the respondents. Public Service Commission seeks time to produce the material on which the final list dated 11/5/2020 came to be revised on 39/2023. The Learned Council shall also get instructions as to the provision of law under which the revision has been effected. List after 3 weeks, the interim order shall continue in force.
Much obliged.
Interim order is with respect to status quo, madam. Status quo, entire selection.
He will continue. The person who has been appointed will continue. Yes, person appointed in 2021. You suddenly come up and say that the list itself was bad. You should have, whose fault is that? This is not why we entrust appointments to a constitutional body. We are under the impression that you will not err, which is why.
That's all. Revising the list, it was, came to the knowledge of one of members of the, there we have.
After 2 years, how can you revise the list? After 2 years, what made you?
What made you revise the list?
Since we received Form 7, my lords, we started looking to the list wherein the less meritorious candidate was put into the list. So that needs to be corrected as well. That has been.
This is very concerning because these are the Election Commission and the Public Service Commission are some of the bodies which
I understand.
we place so much of reliance on, faith on. If this is the kind of, if you're saying that we made a list, it was wrong, we
No,
revised it after 2
first
weeks,
submission
that's
was on
provision.
such a thing where what was the fact that needs to be brought before your lordship, because I cannot make any other submission which is not there on the record. So very first line was my submission was that, my lords,
The
that needs to.
main purpose is that it must be in the order of merit that the selections are conducted. That is why we have a constitutional provision for a selection commission.
Since she was less
This is the
meritorious, my
kind of
lords, we
selections you are
revised the
conducting.
list.
If this is the kind of selections you are conducting, all selections are open to challenge on the ground that
No,
that is not contemplated.
Very very rare case on such, my lords, where the less meritorious candidate came into in and where it was not challenged by any.
Normally they have to publish the answer. Don't you publish answer keys?
We'll publish, my lords. Earlier we were not, by way of the judgment of this
Provisional
honorable
list
court, provisional list.
will contain the marks.
Please, madam,
Then
it
it will
contains
be
the marks.
supported by the answer keys.
Please, madam.
How can you say that there was a mistake?
No, answer sheets will not.
Answer keys.
Answer keys will.
Answer keys are
Please,
published,
will be.
marks are published
Please, my lords, it will be.
along with the draft list. I mean,
Provisional
along-
list
along
itself
with
is
the
the draft
provisional-
list.
Corona, my lords. I was in village. I don't have any.
It's on the website.
It was on the KPSC website, my lords.
Yes. Please produce the material on which
Please,
you came to the
I'll-
conclusion.
By the time final
That
list
is
was
the
arranged and when I started inquiring that's when my lords revised list came to picture.
Place your pleadings on record, we'll consider.
Yes.
We'll do. Yes.
Much obliged.
R4, who appears for R4? Not served.
Notice needs
Served,
to.
served, my lord.
R6.
R4 does not appear to be served, council. Please see
Lords,
that.
R4 is the principal of the college where she is working, may not be required in this case.
Let her take
Yes.
out notice.
Yes, my lord. I will take out notice, my lord.
Please take out notice. See that it is
Yes.
served.
Yes, my lord.
Not any specific date. 3 weeks, it's also good.
For that. Thirteenth of August.
Please.
Much.
Much obliged.
That needs to get.
Lord, this is yesterday's matter, my lord, with regard to Lord, Section 213 of the, my lord, Motor Vehicles Act prescribes, my lord,
But may take
Section
my
213.
preliminary objection to the maintainability, my lord. Because if the candidate has not has participated in the selection process, they cannot challenge the selection process after
Also,
being
we'll hear
considered.
it.
Lord, it is not a selection, Lord. My learned friend is making.
It applies
submission.
even to, there are judgments
is
even
promotion.
for promotion.
It does not, Lord,
There are judgments even on promotion.
preliminary objection with regard to, Lord.
Lord, there is a criteria prescribed. They are aware of the
Let us-
criteria.
Let us
Participate.
go through these files. Here you are. Pass over.
50, Anil Kumar R,
For the respondent, Lordship has heard this matter. They recollect is a transfer where the person who is posted without posting after the transfer, once he reported before the competent authority gives the fine. Posting, whether it is a transfer or posting is them. Now the advocate general, AG has to pay. Only thing is your Lordship has asked. ಇಲ್ಲ ನೀನು ಸ್ಟೇ ಆದ್ಮೇಲೆ ನೀನು ಪೋಸ್ಟಿಂಗ್ have you requested? He contended that I have not made a request. ಆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕ್ತಾರೆ. What I am placing. Last time. The Lordship has asked me after the stay, had you made any request to continue in the post? Senior counsel contended that there was no such request. That is the reason I placing the documents in which we placed for the bone of contention as in spite of the stay, I have not requested to continue in the post. It was refused by the government to continue. ಕೊಡ್ತೀನಿ. Thank you.
Yes.
If I request your Lordship, kindly take today's document to show that I have made.
Yes.
Annexure R1, your Lordship, the document. Annexure R1, page 13, your Lordship is Kannada. Page 15 is the translated copy.
Yes.
Order of stay granted to the official memorandum dated so-and-so of the Honorable Regional Commissioner, Bangalore Division, Revenue Department, as per order dated 4/8/2023 of the Honorable KIT in application number so-and-so. This was submitted to the Principal Secretary with a request. Lordship, kindly come to page 16. As per the official memorandum of the Honorable Regional Commissioner at reference to, it is ordered that the reposting has been given to me to the post of Revenue Shirastedar Taluk Office, Kolar Taluk, from the post of JHM. But in fact, the said order, the Honorable Karnataka State Administrative Tribunal, Bangalore, in application number so-and-so, dated 4/8/2023, has granted an order of stay as per reference 1. Wherefore, I hereby request you to not to issue any other transfer order to the post of JHM in the Office of Deputy Commissioner, Bangalore City. I'm herewith submitting a copy of the said order of stay for kind perusal. This is for the state I have submitted. To the place in which I am working, the next document, Annexure R2. This is on 7/8/2023. Request your Lordship kindly come to page 19.
Yes.
The translated copy. Requesting regarding duty report in the post of JHM as per order of stay of the Honorable KT in application number so-and-so dated 4/8/2023. With regard to the above subject, I, S. Santosh Shirastedar, have reported to duty on 25/7/2023 for known and discharging duties in the post of JHM, Office of Deputy Commissioner, Bangalore Urban District, as per the directions of the Honorable Regional Commissioner. As per the official memorandum of the regional commissioner at reference to, it is ordered reposting me to the post of R.R. Shirastedar, Taluk Office, Kolar Taluk from the post of JHM. But in respect of said order, the Honorable Karnataka State Administrative Tribunal, Bangalore, in application number so and so, dated 4/8/2023, has granted an order of stay as per reference 1. Wherefore, as per the order of the Honorable Court, I have reported to duty in the post of JHM, Office of Deputy Commissioner, Bangalore Urban, on 7/8/2023, forenoon, and hence I hereby request you to accept the said duty report. The interim order has been continued from 4/8/2023 till the disposal. I request your Lordship kindly take annexure R3, page 21. The translated is 23. Page 23, annexure R3. This I have submitted on 12/9/2023, your Lordship. 22/9/2023.
You were drawing your salary also?
No, I'm drawing in my salary. No, because they have not allowed me to discharge till the disposal of the application. After the application, I have been reposted once again. That is the reason your Lordship has asked me whether have you climbed to seeking for the post. After my requisition, when subsequently the petitioner hearing has been posted, even stay is granted, that was also communicated to the government. Government was very much aware from 4/8/5/8/2023 itself, that post is already stayed by the court in which I am working. For these documents, the government has issued a clarification in which the learned advocate, additional advocate general has placed. That is annexure R5, page 30, your Lordship. This, for all these documents, this was the clarification issue.
Yes.
Page 30. The translated copies is 32. This is dated 18/10/2023. With reference to the above subject, Shri S. Santosh Shirastedar has filed application number so and so before the Honorable KT, challenging the order dated 1/8/2023 in the official memorandum, and in this case, the Honorable Court has granted an order of stay, and hence you have sought clarification order as to whether Shri Sridhar Murthy, Deputy Tahsildar, Dasanpura Taluk Office, Bangalore, North Taluk, Bangalore Urban District, has to be taken on duty in the post of JHM, Office of the Deputy Commissioner, as per the government order, or should await final orders of the Honorable KT. This was the clarification made by the Regional Commissioner as a Deputy Commissioner. For that, the reply is now. On verification, order is issued transferring Shri S. Santosh Shirastedar to a vacant post of JHM in the Office of Deputy Commissioner, Bangalore Urban, as per official memorandum dated 24/7/2023 of the Regional Commissioner, Bangalore Division. The heads of the department are permitted to effect the transfer during the period of general transfer during the year 23-24. That is from 1/6/2023 to 3/7/2023. As per government order dated 35/2023, 16/6/2023, and 36/2023, to consider any transfer thereafter, approval of the Minister of the concerned department with the approval of Honorable Chief Minister has to be obtained. Order transfer dated 24/7/2023 by the Regional Commissioner, Bangalore Division, is made after closure of the period of general transfer. In furtherance, as per the aforesaid order of posting of the Regional Commissioner, Bangalore Division, under official memorandum dated 1/8/2023, Shri Santosh S. Shirastedar is reposted to Kolar. As per this order dated 3/8/2023 forenoon, under official memorandum, the said official is relieved from the post of JHM and directed to report to duty in the repost place. On the basis of this information, under orders so and so, 27/9/2023, Shri Sridhar Murthy, Deputy Tahsildar, Dasanpura Taluk Office, Bangalore District, is ordered to be transferred to a vacant post of JHM, Office of the Deputy Commissioner, Bangalore District, by obtaining approval of the Honorable Minister for Revenue and the Honorable Chief Minister. As the Regional Commissioner has withdrawn the order of transfer of Shri Santosh Shirastedar to the post of JHM, Office of Deputy Commissioner, Bangalore District, the Regional Commissioner, Bangalore Division, is separately intimated to submit para-wise remarks in respect of the application filed by the said official before the Honorable Court, and objection statement, and take action for getting an order of stay of the Honorable Court vacated, and to take steps getting the said application dismissed. Since an order of stay is obtained under application number 3505 of 2023 and 4377 of 2023 to the official memorandum of Regional Commissioner, Bangalore Division, I am directed to inform you to accept the report of Shri Sridhar Murthy, Deputy Tahsildar, Dasanpura Taluk Office, Bangalore District, in the vacant post of JHM, Office of Deputy Commissioner, Bangalore District, as per government orders, subject to final orders of the Honorable Court in this case. Though this is only a clarification issued by the government,
the government was very much aware about the fact that the stay is granted to my shifting of that post on 4/8/2023, because I have communicated on 5/8 to the principal secretary, as well as I reported to duty. They never allowed me to discharge my duty. The stay is continued till the date when the petitioner hearing is posted on 27/9/20. Even after 27/9, that order is also challenged before the tribunal in separate application, stay is granted. Then all those things has been referred by the regional commissioner to the government. What I supposed to do? Since stay is granted, I am not allowed the first applicant to report for duty, in spite on the ground that I have been relieved. Whether can I take the duty of the subsequent person who is posted when the stay is over? For that, this clarification is issued. And further, the government itself has filed a statement of objections before the tribunal. Annexure R6, page 36, request your lordship kindly take. It is not their case that I have been transferred, I have been posted. Posting is something different, transfer is something different. That is clarified by the government in their statement of objections. Annexure R6, page 36, your lordship, in the same document which I have given. Today. The last annexure of page 36.
Yes.
I skip all the para. I will read from para 3, your lordship. I may be permitted to. This is the statement of objection filed by the state. It is submitted that as per the circular dated 35/2023, Minister of the Department is authorized to carry out the transfer of the government servant for the year 23/24. As per the directions of the Minister for Revenue, the competent authority has transferred Shri B. or Anand, the Deputy Tahsildar, to the place of applicant through wide order dated 3/7/2023. Hence, the applicant has to report before the competent authority seeking for further posting. Because I have not been given posting, so I am supposed to be report only before the appointing authority is my competent authority. Applicant reported before the competent authority, and again through wide order dated 24/7/2023, applicant was providing that posting to the other place.
Yes.
It is submitted that as the applicant was waiting for posting in the office of the respondent number 2, has given posting in the city headquarters in the office of the respondent number 3 is available in available vacancy. However, the said posting was withdrawn in public and administrative purpose, and the applicant has been transferred as Shirastedar Taluk Office, Kolar. So I have not been transferred. I have been given posting. Once the posting is given, I have reported. Once I reported, my tenure starts from the date of reporting. There is no question of withdrawal by the competent authority. Then the next course of action is only required under transfer guideline. Yes, for posting, I am not supposed to go before the government. This is my response.
Yes.
The issues with regard to the regional commissioner's office, who is the appointing authority, and Milords with regard to the state government powers. Usually, Milords, what happens is if apart from the state government, if any other authority is the competent authority for the purpose of postings, then Milords, only if they're compulsorily waiting and if there is a vacant post, Milords, they can give postings. That we are not disputing the settled position with regard to that. It is an admitted fact, Milords, that the regional commissioner is the appointing authority, Milords, for this post. And as on the day, Milords, when the initial posting order was issued, that is on 24/7/2023, Milords, that post was vacant to which he was posted. He was waiting for posting. The regional commissioner has given a posting. But Milords, what happens? We are facing the same situation, Milords, where there is the commissionerates and directorates. We have commissionerates and directorates in different departments, like the health as a commissionerate, and some other departments have directorates, where, Milords, there is a director or a commissioner also who is a competent authority for some post. But at the end of the day, Milords, for the entire department, under the transaction of business rules, Milords, it is the state government, Milords, which is a competent authority for the purpose of postings and transfers, and it is a minister's approval that has to be taken during the time of the this is prior to the in the previous 2013 2013 guidelines, Milords. It was the minister in charge who had the power, Milords, during the term of during the general transfer period. Beyond that, Milords, it is with the chief minister's approval the transfers could be effected. Now, in this case, Milords, on 24/7/23, when the posting was given, he has reported. But Milords, having then thereafter, Milords, on 1/8/23, this was withdrawn. Now, his case is, and immediately he approaches the tribunal, and there is an interim order of stay. Thereafter, Milords, 27, while the stay was operating, these are facts, Milords. There is no dispute on these things. They are borne out by records. So on 27/9/23, the petitioner herein or the private respondent before the tribunal, Milords, was given a posting to the post, Milords, which was withdrawn, and he was asked to report to Mysore.
Stay was operating.
Stay was operating, Milords. It is. Now, Milords, the only thing is this. It is in respect of the post, Milords, at Bangalore. while the stay was operating, the posting order was given. My lords, it was whether it was actually to the knowledge of the government of the person who was actually issuing the government order. I just want to place this on record. My lords, we have had this situation where the commissionerates, my lords, have their separate offices. They are operating at that level, or the directorate, or here it is the regional commissioner who is the competent authority. Now, my lords, he has certain statistics of certain vacant post at that point in time. There, my lords, files will be moved for other postings, treating it as a vacant post. While, my lords, by the time this happens, if some other interim order is granted there because of some other posting order that has been given to a vacant post, we are not, my lords, there has been no deliberate, my submission, my lords, says that there has been no deliberate disobedience or violation, my lords, of the tribunal's order. But there has, this is what actually transpired, that by the time, my lords, it was to the notice, or the file notings would have moved already. And by the time posting order was issued, my lords, maybe there is two conflicting orders here. While the stay order was there. Now, my lords, one fact needs to be noticed. While the stay order was, after he gets the stay order, my lords, even as on 27/9/23, when the posting was given, my lords, he is now producing records, but for 7 months, he did not go, he says I reported, but for 7 months, my lords, he did not work in the post. Only after the final order was passed, he goes back and he takes charge. Once the final order was passed, for 7 months when the applications were pending before the tribunal, he has not worked in that post. So thereafter, my lords, in the meantime, the other posting was given. Now he himself, my instructions, my lords, are, now he is seeking for the private respondent here in the original applicant. He is now seeking for post, he is now, through some recommendations, he is seeking for posting, my lords, to a Devanali post. And that is under process. And at the same time, he is also contesting here, my lords,
sorry to submit.
No, no.
I am not claiming any post other than this. This is my submission before the court.
No,
This is what behind my back something is going on. That is the reason I'm placing before the Summer Court. I have not sought any recommendation. Even otherwise, in spite of the stay order, I reported they are not allowed me to discharge. Is my restrictive submission.
Lords,
Only that clarification.
If need be, my lords, I can place those tippanis on record. My lords, on the basis of that, my lords, there is a transfer file is being moved for the purpose of accommodating the petition, private respondent here in, my lords, to at Devanhalli. There is a posting that he himself has sought. Now he is saying that he has not moved it. That is his submission, my lords. Now, insofar as, my lords, my submission is on the basis of the records that are available, on the basis of the dates in view of the stay order, my lords, these are bare facts, my lords. I will leave to the court, my lords, for the purpose of passing any order. But the fact remains that while a post could be vacant at a particular point in time, and a person is waiting for posting, and the appointing authority, my lords, gives a posting to that person. In the meantime, my lords, at a different level, at the state government level, there could be a file which could be moved, treating that as a vacant post. And in the meantime, my lords, but at the end of the day, my lords, it's the state government orders which has to prevail, is my respectful submission. And because the residuary powers under the transaction of the business rules have to override, my lords, any specific provisions under the CCA rules, where a particular appointing authority has been given. So, my lords, and one more submission, my lords, is that now the petitioner, my lords, the private respondent here in original applicant, is discharging his duties, my lords, at Bangalore. On the basis, after the interim order of, after the final order was passed, quashing both the orders. Both the orders have been quashed now, and he is discharging duties there. There is, he is disowning it, but as a matter of record, it is a matter of record, my lords. It has come to my notice, and I have instructions to submit that there is a proposal, my lords, at his request or through some recommendation, my lords, for purpose of posting the respondent number, private respondent, my lords, to another post. He has sought for a posting basically, and it is under process, my lords. So if it could be deferred, my lords, we could, but if he does not want it, let him make him a statement, my lords, we'll stop that process also.
I'm making a specific statement that my client is not inclined to seek any posting behind my, he is contesting this case from past 1 year for the reason that having posted, having reported now.
Yes.
This is my submission.
So please, my lords, so I'll leave it at that, my lords.
Yes.
Please come to 83 minutes. That in the writ petition, that's his application, second application where he challenged my transfer order.
Yes.
Now, my lords, his case is, today he produces a memo with several documents saying that, if I recollect, my lords, your lordships had queried as to whether he had made a pleading in the case. Now, my lords, he says I was not allowed to report to duty in spite of an interim order of stay in the first application.
Yes.
Lords, if that was the case, he could have moved for a contempt. He does not do.
The second application is page 83, please see, my lords, it's about 3 pages or 4 pages of that application. Not a single sentence that he is carrying out duty. He reported, he was refused to report for duty, that is taken charge pursuant to the stay order in the first application. Not a single sentence.
Yes.
But today he brings out this, my lords, he could be working out several things. My lords, these letters, they work out, there are several things which happen in the government level, which we are not aware. Or my lords, the employer, the service personnel will be aware. Probably he was, my lords, trying out, my lords, I can only assume that he was trying out to get some other posting. Today he says, but this should have come before the KAT that I reported. After the interim order, my lords, he was relieved on 1st of August 2023. The interim order of stay came on 3rd of August 23. Thereafter, my lords, yes, my lords, sorry, 4th of August is when he is, my lords, I'm sorry, he was relieved on 3rd of August. 1st of August is the one which withdrew it. Now, my lords, from 4th of August, he does not even go before KAT and say, move a contempt. My lords, if the state did not allow him to report back, he could have moved a contempt. He does not do that. In the second application, he could have raised that this post is not vacant. I have reported, it's under my charge. Not a single sentence there that say all these documents could have been produced before KAT.
Page 87.
Let's please see page 87. Let's. Yes, applicant was prematurely transferred to Kolar, to Kolar on 1/8. Same has been questioned. This honorable court pleased to grant an interim order on 4/8 and the said interim order is in place. The interim order has been communicated and the respondent was requested not to post anybody. That's all. Now, my lord, does he say, please see, however, knowingly first respondent has posted the fourth respondent in place of the applicant as if the post is vacant. Said action amounts to contempt. That, my lord, does he say that I have reported, I have carried on with the duty?
Next, 3C.
Let's
3C.
please see, by virtue of the, that's what, my lord, by virtue of the interim order by this tribunal, the applicant is working. Now he says I was not allowed. That itself is contrary statement. That is 3C, he says I am working in the office. Now he says I was not allowed to. That's why, my lord, if 3C is taken into consideration, the attendance register should bear out that he was working. That is not there. Today he files these documents to see. Lords, it is not, admittedly is not working.
Just one submission, my lords, in the memo that he passed on today, Annexure R1, that document, my lords, is with the state. Annexure R1 may kindly be seen, my lords, the memo he passed.
That is page 102. They have placed translated copies. They have not.
Yes.
R1, my lords.
Yes.
Page 13. Translation is at page 15. On page 13, my lords, there is a seal.
Yes.
My lords, here, this document, my lords, we have, it has been received by the state, but all he says here is, please don't give me posting to anything, to any, not to post. But on 7/8, he says he's reported there, but according to our records, my lords, for 7 months, he's been unauthorized absent.
Yes.
And now I am without any posting also.
Sir.
In urgent, 17, here Prasanna Shetty.
Petitioner, my lord, for the filed application, dispensation of translated copies.
Sorry?
I filed application for dispensation of translated copy.
Yes. The lockdown condition.
Please. And also, my lord, the statement of objection filed by the government before the KAT, my lord, is not available. Please.
We'll try to give him a copy, man.
Yes, please, make it available. Yes.
Please, my lord, that. In
Notice
this
to the R3.
Though KVT has been filed, but it is, my lord, lapsed, I think, 90 days first mover. That's why. I'll take notice to R3, my lord. R1 and 2 government.
If the reply statement is available, please
Please.
make available a copy.
Please. And my lord,
Advocate, the reply statement of.
I will verify that.
Honorable KSAT, my lord, reappreciated the evidence and my lord allowed the application. Though my lord, the material witness have supported the case of the. Okay, please,
Notice.
please, apply.
Further hearing? Still number 18.
This is a case where, my lord, all earlier litigations ended. It went to Supreme Court in 2 occasions. Then again filed a fresh application. The tribunal said, quashed the endorsement, directed to consider representation. And this court, while hearing, granting interim order, considering all the facts, my lord, granted interim order.
Yes.
Now, my lord, only he is asked to file representation, lord. Translation copy of the representation.
Sorry?
Translation copy of the representation which is in Kannada.
Yes.
All will establish, my lord, that regarding ranking in the selection list and seniority shall be prefixed as per the Daria's case. All representation, repeated representation.
Lordships. Let the petitioner make the submission, Lordships. After that, we make a submission.
Petition submissions are over. It's only to hear you that we had posted.
In that case, it may be passed on, Lordships.
But I only rely upon the 2 decision which I have already given. Kindly take that extra citation which I have given by the learned advocate on record. Repeated representation will never.
Yes.
2018, Lord, volume 5, page 14. There are 10 onwards, my lord, this question is considered.
Yes.
Page 18. Citing, my lord, number of decision. Mayor repeated filing of representation could be sufficient to explain for delay in approaching the court for grant of relief. Was considered by the so and so case held as follows. Then, my lord, para 11. Ultimately, my lord, court says, my lord,
Yes.
repeated representation cannot be the reason, my lord, to entertain the application. Then, my lord, delay and latches. Order 2, Rule 2 of CPC would be applicable. Section 11, Order 2, Rule 2 CPC would be applicable.
Yes. Constructive.
That's all the.
Right and orders. Yes.
Private respondent is that he has never made a request. All along, he has fought for selection. Not the better ranking in the select list.
So does the.
Not kindly come to, yes, not he has made such prayer in the earlier round. Not the submission of the private respondent that not he has never made request for not seniority with reference to the merit list is actually page 203 for a moment.
Of
But, in the petition 2139 of 2022.
Here. Yes, it's here. Yes.
Yes.
213.
Page 213.
May I take leave?
Page 203. 203. But the entire argument is structured on the submission that he has never claimed.
Yes.
These review applications have been filed seeking review and recall of the order of this tribunal in application number so and so. But in that prayer number 3, issue a writ of mandamus or any other writ or direction to the respondent number 1 to 3, prepare the seniority, kindly note.
Yes.
Prepare the seniority gradation list after considering and correcting the marks secured by the applicant in their qualifying examination on par with Madhusudan Reddy. But he has claimed seniority with reference to the merit list, not, which is rejected. This was tested, my lord, at next order, page 208. Before, my lords,
Yes.
he has failed. Against that, my lord, SLP is filed. SLP, my lord, he has withdrawn and with liberty to this is the latest judgment of my lord, the coordinate bench, but rendered on 28/6/2024, which suits my case, my lord. How litigant, unscrupulous litigant is to be, my lord, curbed from filing application, writ petition one after another. But with minor changes. Copy served, my lord.
Yes.
Copy served, my lord. But in the case on hand, my lord, writ appeal number 348 of 2024, Lord, fourth time, my lord, with minor changes in the prayer, Lord, approaches this honorable court at page 18. But the contention is noted at page 18, my lord, para 4.2.1. Does not senior counsel for society invoke the principle of estoppel by a representation so for the proposition that a person taking recourse to legal proceedings over and over again amounts to abuse of process of law. Decision of this High Court in so has relied upon on which it was held that filing of repeated representation on the same cause of action and approaching different courts for the same relief by making minor changes in the prayer amounts to forum shopping, tends to become contempt. Lord, the finding starts from para 5.1, page 21. Abuse of process is Lord,
Yes.
page 21. Lord, what I have read out to your lordship is, my lord, contention. But 5.1 is the abuse of process of law and misuse of court machinery may arise in several ways. The writ petitions, statutory appeals, and other legal remedies in these days more often than not become exploitive tools in the hands of unscrupulous litigants to protract the litigation somehow and anyhow. Thereby, such litigants not only succeed to avoid discharging of their legal obligation, they prevent the bona fide litigants, the other side, from reaping the legitimate fruits of litigation. Ill-intentioned, then, my lord, ultimately, my lord, para page 25 at para 5.1.5, it says that it amounts to not the forum shopping and in fact.
Yes.
Which ultimately, my lord, this honorable court imposes, my lord, the cost. And Lord, my other submission is not order. It is hit by order 2, rule 2. If we had intention of claiming Lord seniority,
Should have been done at the
he should have not claimed at the beginning. In the Lord, he has initiated proceedings. First application filed by him is my lord in 2007. I am sorry, 2011. I am sorry. 2011.
349 is contested.
Lord, at page 8, annexure 825, but the very same submission was made.
No second round of application.
May I request, my lord, kindly turn to page, page 351.
From 3 onwards.
But para 3 is his contention.
Yes.
But page 351. He is represented by very same counsel who is represented, my lord, the private respondent. But the contention is at para 3. And contention is considered rejected. All along from 2011 to 2024, these submissions are made and considered.
Yes.
And
Yes,
for the
yes.
first time, my lord, he has claimed seniority is not actually incorrect.
Yes.
That's the submission, my lords, that I have claimed seniority for the first time would itself note, my lords, that the earlier judgments would not operate as res judicata. Would your lordships just give me a moment, my lords? Grateful.
Lord, may I just complete my.
Yes.
Yes, I'm sorry.
State.
Well, is this what we call a marathon argument? After the marathon?
No,
Yes. No, please.
Yes.
We'll hear the.
You filed a statement of objections. Not taking extent. This is a circular issue, stating that how the seniority has defects after the additional list candidates are appointed.
Yes.
It clearly says that in the order, this is an order. In the order, it says that those appointed in the additional list should be placed below those in the.
That was your
This is in the
written
order,
objections
and this
before
is
the
not.
tribunal. Your written objections.
We have
before the
not filed.
tribunal or here?
Not filed. Not filed.
My lords, the order,
That you have filed.
order sheet is produced at 383. Only in 2 hearings, my lords, the tribunal, my lords, reserves the order.
Yes.
Tribunal, my lord,
Yes.
issues notice on a day. Next day, my lord takes up and
Yes.
This has not been challenged. Is the.
Yes.
We adopt all the arguments of the
Yes.
court case. And also it is barred by res judicata, my lord. I'll present the judgment of
Yes.
Supreme Court where it says that consular constructive res judicata is.
Yes.
The last date I completed my submission.
Yes.
That's why I've made my written submission. Briefly, only 3 points. My lord, I'll pass it on.
You've made the written submission?
Yes, my lord, I'll just pass it on. Before that, only 3 submissions.
Yes.
My lord, if the question, my lord, is to be decided on res judicata, whether, my lord's writ petition is maintainable, and this court, my lord, by 3 orders had directed them, my lords, to answer the question as to whether writ petition is maintainable. In the order sheet, it is noted, because they were not parties, admittedly, and therefore they would have to file possibly a review petition. Writ is not maintainable. My lord, my second submission, my lords, insofar as res judicata, the earlier judgments are sub silentio. Last submission is, my lord, when the Supreme Court said work out other remedies. My only remedy, my lord, was to give a representation. All that I'm saying today, let my representation be considered. I'm not seeking for any further direction. They can't say, my lord, that the order of Supreme Court is a nullity today because he can't even give a representation. Therefore, my lord, I'm restricting my prayer, despite what has been granted, only to consideration of my representation. That's all.
Yes.
My lord, I'll just pass on all the notes to the court officer after submission. Great.
Yes.
Grateful.
But in the prayer, my lord, consider representation favorably in favor of the.
Consider.
I can't say unfair.
Yes.
Great.
My lords, may I only place on record the synopsis, my lords, for your lordship's perusal.
Stone matter, number 10, K.M. Prakash.
Lunch, we'll make an attempt. Or do you want it on some other day?
It was just there, my lords, I don't know. We waited for it. Income. Sir, password, password. Pass it over. Let's me pass it over. Was there? I don't know. He was just there, my lord, to be frank. I have no issues.
Yes. Without it. It's passed over.
12.
Pass away.
Pass.
Well, passed over. Some point. What's it not?
And serial number 12, my lord, in fact, we made an inquiry. My clients have also come. Because other than the petitioners and the, my lord, and the respondents, now the steps are being taken to give promotions, my lord. The lordship can, my senior counsel made a request for, my lord, till 30th, my lord, your lordship can
Yes.
let them not go.
That was the case where the additional, the advocate general was to appear.
Yes.
We'll say that till
Till 30th, my lord, we will argue the matter.
further steps.
He
It
has
is
not
not
yet
in
come.
their interest, it is whether it is
may
absolutely
be on his
required
way.
for you.
He's coming. Apologize. He was here.
Yes.
Serial number 10 called twice. Second time I was not there. I'm applied for.
All right. You're ready in serial number 10?
Yes.
What is the issue?
Not ready.
Last time, my lord.
Regarding, without challenging the notification, my lord, regarding the 10+2 PUC is treated as JOC. So we have contended that without challenging the notification, you cannot maintain the.
Doctor, no, stop. Relying on the same judgments in the other matter.
To that, my lords, to that effect, my lords, I found as a decision, my lords, where the
I'll
opinion
point out the exceptions also. But at the
wherein
end of
it
the day,
says,
what is right should prevail. We are state and we intend to be impartial.
lords, in one of the decisions, my lords, if I may pass. Admittedly, my lords, I have not challenged the selection. This one notification, I go down to that, my lords. But this particular judgment at paragraph 17, my lords, if the lords may see. Number 3. It says, my lords, para 17, my lords, is page 13. My lord, it says what exactly my lords held that if illegality is there, I can challenge.
Page?
13, my lords, para 17. Accepts the prescribed procedure and not the illegality in it. In a situation where a candidate alleges misconstruction of statutory rules and discriminating consequences arising therefrom, the same cannot be condoned merely because a candidate has partaken in it. The constitutional scheme is sacrosanct and its violation in any manner is impermissible. Lords, what my lords have held, same thing is held. I'm relying on.
But this is an exception I pointed out, which doesn't arise in this case. This is a case where it amounted to violation of Article 14 and 16, my lord. Discrimination resulted from the misinterpretation of the provisions. Therefore, that is not a
Here
not similar to in this case. My lord,
PUC and GOC.
may I just,
Yes.
my lord, the government feels that there are two different courses, and my lord, and specifically very categorically it is said that in the notification, those holding JOC are not eligible. My lord, that has not been challenged. Your lordships may kindly see this decision, my lord. It's a very recent decision of 2023.
It's not the government. The government had done it,
The-
but it's another, not the government.
The
Government chose not to.
the
amend
selecting
the
authority.
rules.
The selecting,
There is no such
the selecting authority.
specification in the rules.
Please.
Selecting authority departs and adds.
But several, the very similar case, my lord, several decisions have been relied on, where the rules, the selection process were alleged to be contrary to the rules. There, your lordships may kindly come to paragraph 68, my lord.
Citation
344.
Yes.
68, my lord. The next aspect of the matter which requires consideration is the contention of the writ petitioners to the effect that the entire selection process was vitiated as the eligibility criteria enshrined in the advertisement notice dated 5.
Just a moment, can we stop for a moment here?
Please.
These are matters where the challenges is against the selection process as a whole.
Election.
When a person says that I have been wrongly denied appointment because of a wrong process, wrong provision.
The notification not being in consonance with the rules.
Exactly. Then he does not say that the entire selection was bad. He only says that I have been denied because of this wrong prescription. There is a slight difference in the
But in
the
Dhananjay
situation.
Malek, on the last occasion, I submitted the judgment. Even that case is relating to the notification not being in consonance with the rules.
Is not the question. The prayer here, when the next aspect of the matter which requires consideration is the contention of the petitioners to the effect that the entire selection process was vitiated as the eligibility criteria enshrined in the advertisement notice dated so also was recast by the corrigendum without any justifiable reason. And
My lord,
ultimately
several
the
decisions
finding
are
is-
noticed, my lord.
Yes.
May I just take your lordship?
Ultimately, the finding is therefore tried that candidates having taken part in the selection process without any demur or protest cannot challenge the same after having been declared unsuccessful. Absolutely right. The candidates cannot approve and reprobate at the same time. In other words, simply because the result of the selection is not palatable, he cannot allege that the process of interview was unfair or that there was some lapse in the process. Therefore, we find that the petitioners in these cases could not have questioned before a court of law the rationale behind recasting the selection criteria, as they willingly took part of the selection process even after the criteria had been so recast. Their candidature was not withdrawn in the light of the amended criteria. Challenge was thrown against the same only after they had been declared unsuccessful in the selection process. At which stage the challenge ought to have been integrated, ought not to have been integrated in the light of the principle of waiver and acquiescence. Only exception is the existence of malafide on the part of such selection. Any arbitrariness in the selection process. Yes.
The judgments relied on, may I just take your lordships through the second judgment which is relied on. In para 68 itself, the Romanet 2.
Yes.
Ramesh Chandra Shah versus Anil Joshi.
Yes.
An advertisement was issued inviting applications for appointment to the post of physiotherapist candidate who failed to clear the written test, presented a writ petition and prayed for quashing the advertisement and the process of selection. They pleaded that the advertisement and the test were ultraviolence the provisions of the Uttar Pradesh Medical Health and Family Welfare Department Physiotherapist and Occupational Therapist Service Rules 1998. After referring to a catena of judgments on the principle of waiver and estoppel, this court did not entertain the challenge for the reason that the same would not be maintainable after participation in the selection process. The pertinent observation of this court are as under. In view of the proposition laid down in the above noted judgments, it must be held that by having taken part in the process of selection, with full knowledge that the recruitment was being made under the general rules, the respondents had waived their right to question the advertisement or the methodology adopted by the board for making selection, and the learned single judge in the division bench of the High Court committed a grave error by entertaining the grievance made by the respondents. But even in the other case, my lord, it is found that they prescribed marks weightage criteria. Even in the next case, my lord, Ashok Kumar versus State of Bihar, marks criteria was prescribed which was contrary to the rules. And that was the challenge was repelled on the ground that they are stopped on the ground that they had acquiesced to the selection process.
68 point.
Lord, I have a
Madam.
Sir.
Notes ಮಾಡಿದ್ದಾರೆ, more different position.
This contention, he has not challenged the selection, that is another matter. If you're contending that participation in the selection will preclude any challenge, nobody can challenge any selection. How are the judgments of the district judge
They have
selections
to
coming?
participate. There are decisions. I have made a complete list of.
Not participate and then challenge it.
No, they have to participate by under protest. That is the.
Yes, consider.
Once they participate, they have acquiesced to the selection. I made a complete list of all the decisions.
Yes.
On this.
So he has participated with necessary qualification.
Yes.
Described under the rules, described under the rules.
Yes. But
Yes.
That's the decision. here.
No,
If
qualification was not there, my lord, in this case, but
You can't tinker the qualification.
you're tinkering that made him unqualified.
my lord,
Whether you can be heard to say that the relief, if any, granted to him was incorrect is the issue.
actually, just now, my lord, received this letter, I will just pass on, if my lordship permits, it's in Canada.
All right, under which provision you have prescribed the qualification?
My lord, C&R, my lord.
What does it say?
Clearly says.
My lord, in the government itself, my lord,
You see
returned
time
this
plus
letter
two.
to the KPSC,
Government cannot write such letters.
stating that, since the government has not,
Cannot write
declared
such
the
letters.
equivalence, not to consider, that's the,
Government cannot write such letters.
based on this, my lord,
They will have to amend the rules.
that's true, my lord, even, hold on. The only two things, my lord,
What is a letter?
it says
It is a letter written by the government to the PSC.
not to consider the JOC
It
candidates.
is not even an order under Article 162. Is it? How is the executive power of the government to be exercised? Writing letters?
This one officer has misinterpreted the rule, as simple as this.
That is only the personal opinion of that officer who writes the letter. How are you bound?
In this case, particularly two things, my lord, I am not going to press more than this. One is, there is no challenge to the notification.
That is what is
One.
fairness is.
One, my lord.
Everything else
This,
we could go.
the second one is, it's also plays important thing, my lord. Similarly placed candidates have not before my lordship, because of that are not participated in.
Because of your fault. In having tinkered with the qualification. How can you be heard to say this? Again, that's the question. You make some kind of tinkering with the qualification. You are absolutely not empowered to do it.
That's true, my lord, I will.
And then somebody challenges.
I will bow
He
my
gets a
lord.
favorable order.
It's true.
You challenge it saying that some other person should be. You should have thought of it when you tinkered with the qualification.
Lord, in all these cases, the
Tinkering with
selection
qualification.
process have violated
Tinkering
the
with
rules.
qualification.
No, I'm sorry.
They have not followed the rules. Lord, in the third case, in fact, the selection criteria has not been followed.
And the Supreme Court, my lordship.
Weightage marks which were to be awarded were changed in the third case in para 68.
Manish Kumar.
Not Manish Kumar, but the Ashok Kumar case, state of Bihar. I just read this, Lord. Lord, a process was initiated for promotion to class 3 posts from among class 4 employees of a civil court. In the said case, the selection was to be made on the basis of written test and interview. For I'm reading at bottom of the page, Lord, third one. Similarly, in Ashok Kumar versus State of Bihar, a process was initiated for promotion of class 3 to class 3 posts from amongst class 4 employees of a civil court. In the said case, the selection was to be made on the basis of a written test and interview, for which 85% and 15% marks were earmarked respectively as per norms. Out of the 27 candidates who appeared in the written examination, 14 qualified. They were interviewed. The committee selected the candidates on the basis of the merit and prepared a list. The High Court declined to approve the select list on the ground that the ratio of full marks for the written examination and the interview ought to have been 90 and 10 and 45, and 45 ought to be the qualifying marks in the written examination. A fresh process followed, comprising a written examination, full marks 90 and qualifying marks 45, and an interview carrying 10 marks. On the basis of the performance of the candidates, results were declared and 6 persons were appointed on class 3 posts. It was thereafter the appellants along with 4 others unsuccessful candidates filed a writ petition before the High Court challenging the order of the High Court on the administrative side, declining to approve the initial select list. The primary ground was that the appointment process was vitiated since under the relevant rules, the written test was required to carry 85 marks and the interview 15 marks. This court dismissed the appeals on the ground that the appellants were clearly put on notice when the fresh selection process took place that the written examination would carry 90 marks and the interview 10 marks. The court was of the view that the appellants, having participated in the selection process without objection, subsequently found to be not successful. A challenge to the process of their at their instance was precluded. The relevant observations are as here.
Yes.
They were selected over content.
The well settled principle, my lord.
At what stage do you challenge?
Interview.
When you're not called for the interview?
After he has been held to be
I was
ineligible.
I was not allowed to attend the interview. Direction. But interview ಕೊಡ್ಲಿಲ್ಲ allowed to attend.
Challenge the endorsement.
Endorsement ಇಲ್ಲಿದೆ, endorsement ಕೊಟ್ಟಿಲ್ಲ ಸರ್. They only allow me to continue ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. Representation as Annexure A17 was not considered.
Now tell us, how do we get over you're not challenging the? If it were a case of challenge, we could try at least to get over these judgments.
There's
The
one
situation
thing,
where you do not even raise a challenge, how do we get over?
that is one thing.
And added to that, there is some sort of suppression, in the sense you say it as PUC instead of JOC.
Yes, ma'am.
If you had said JOC on the basis of these, this criteria, wrong criteria, we agree. If on the basis of the wrong criteria, your application would have been rejected then and there. Then you
Could
could
have
have,
made a challenge.
then you could have challenged the rejection, challenging the notification, saying that it is wrong. All others who had JOC qualification would also have been able
But
to.
this honorable court has already had it is PUC, then there would not be any separation for that because it has unless.
They have added that addendum.
That is one
wrongly
thing
added.
is against me, my lords,
Absolutely
where I have
no
not
power.
challenged the notification. I will not take a back step from it.
What do we do? How do we get over that inherent defect?
You could have said JOC, which is equivalent to PUC, that you could have said.
Two
Lords,
things.
what division bench of this honorable court says is it is PUC within the bracket diploma in VOC. So it is equivalent to PUC is
You should have
particularly
said,
what is held.
no, you should have said JOC, this is equivalent to PUC, that you could have said in your application.
And if it were rejected on that ground, that would have given you a cause of action to challenge the notification, saying that it is not there in the rules.
That challenge to the notification is one thing.
I don't know how to get over that. On that short ground.
I'll look into it once again, my lords, the last comment. I'll leave it to my lords.
There is no judgment which says that
That's
you
true.
have to challenge the notification. Please take it from us.
But one thing, my lords, it's 2011 notification. I'm age barred also. I cannot apply for anything. This is
That
on-
applies to all
So-
the other persons who could have applied pursuant to the notification, if it was in terms of the CNR rules.
Lords, the private respondent has also not challenged it. So he has accepted the tribunal's order. So it would not hamper.
Who has not challenged it?
Private respondent. He has not challenged. He has accepted the tribunal's order.
Is he here in these proceedings?
He has not appeared, my lords. Notice has been issued.
Notice has been issued.
Respond number 5.
That will not help my
Not
learned
because of
friend.
defect
Yes,
of
ma'am.
You are not having challenged.
Grateful. Published. Well, senior also is there. This matter, I've just verified with regard to the submission notes that promotions were being affected. All of them are now in the cadre of additional deputy director post. The issue was with regard to additional director upgradation post. Now further promotion notes is to the post of joint director. Now, actually, some 3 other persons who are not parties to this proceedings, who seem to be senior to all of them, had submitted one representation to the state government. We had sent it to the commissionerate on 24/6/2024, asking them to examine the representation and to send a suitable proposal. It is only at that stage. In the meantime, my lords, the private respondent, original applicants have given a representation stating that the matter is pending before the court. That also we have forwarded to the commissioner. So till next date of hearing, formal order, nothing is going to happen. Otherwise,
Formal order need not be passed? Or shall we say that nothing is happening in the?
Nothing.
So the promotions are that.
my lords can say pass an order itself, my lords, so that it can be communicated to this.
As well as testing by this police. Yeah. Participants listed. Yeah, listed it 30th.
30th.
Pensions raised. Further promotions to the post of.
From the cadre of deputy director to the post of joint director.
So deputy director. The relevant department. To get probates. To the next date.
Till the next date. Please.
Number 14.
Vehicles Act.
Yes. Motor Vehicles Act. But I will just reiterate the third judgment in para 68, my lord,
Yes.
because my learned friend was pointing out that it's a case of promotion.
Correct.
So this is a case of promotion in para 68, the third judgment of Ashok Kumar versus State of Bihar.
State of what?
Para 68 of this one, Tejveer Singh Sodhi, the one which I referred to, my lord. Estoppel against an unsuccessful candidate who participates
Yes.
without challenging the selection process. That was a case of promotion, my lord, where
Motor vehicles.
no, I did not. No, the earlier judgment, which was which I referred to, my lord, which I read out in the case relating to PUC versus JOC, my lord. PUC equivalence of PUC and JOC.
Judgment.
Same judgment.
Take it or leave it.
I'll give another copy.
But before, my lord, my learned friend could commence, my lord, I have produced the list of citation where, my lord, the Central Act says a particular qualification. Not in respect of motor vehicle itself is considered by the, my lord,
Yes.
Lord, may I request my lords to
Para 68. Just a
68.
moment. What does 68 say?
But where the weightage was given, different weightage was given to, contrary to the rules, my lord, for the interview and the written exam. The bottom of the page, my lord, at para 60,
Question of interview or exam, it is the very basis for the selection.
height, my lord, height.
Next aspect of the matter which requires consideration and attention
The-
to the entire selection process, initiated, etc., etc. Ashok Kumar.
Ashok Kumar, which is at the bottom of the page, my lord, para 68. A process was initiated for promotion to class 3 posts from amongst class 4 employees of a civil court. In the said case, the selection was to be made on the basis of a written test and interview. My lord, may I just skip everything and come to the primary ground?
Yes.
My lord, this is, my lord, from the paragraph at the top, my lord. About 11 lines from the top. The primary ground that ground was that the appointment process was vitiated. The lordship has it, my lord. The primary ground was that the appointment process was vitiated since under the relevant rules, the written test was required to carry 85 marks and the interview 15 marks. This court dismissed the appeal on the ground that the appellants were clearly put on notice when the fresh selection process took place, that the written examination would carry 90 marks and the interview 10 marks. The court was of the view that the appellants, having participated in the selection process without objection and subsequently found to be not successful, a challenge to the process at their instance was precluded. The relevant, my lord, may I just point out one thing, my lord? In fact, my learned friend in the previous case pointed out from a judgment of 2019 that there was discrimination, my lord. My lord, in that case, my lord, what we notice in this case is a common criteria has been adopted across. It's not different for different people. Now, there what happened is it amounted to discrimination between similarly situated persons. Therefore, my lord, here it is not as though some candidates have been discriminated arbitrarily. My lord, and I'm actually told, my lord, what is the nature of work which a motor vehicle inspector is required to do. It involves, he's required to enforce. He's supposed to be, he's a foot soldier. He's supposed to be on the roads. He's supposed to stop vehicles. He is supposed to do investigation.
What does that have? Right?
My lord, it has an intimidating effect, my lord, on people who may try to.
Intimidation does
My
not,
lord, no,
does not have to come from.
no, I'm not saying that in a negative, my lord.
Yes.
It has a,
Intimidation.
they may have to climb on the vehicles. No, they are also required to climb on the vehicles and they have to do the inspections, my lord. So physical fitness is a requirement. And also, my lord, I found, my lord, may I just also point out, my lord, the central legislation prescribes the minimum qualification. The relevant provision, I'll refer to the judgment of the High Court, which has been stayed by the, which has been intervened, in which the Supreme Court has passed an interim order, my lord. In that case, it has been noticed that the central legislation only prescribes minimum qualification. In this case, my lord, the argument of estoppel was not at all put forth in that case. That is one point. Therefore, that case will not be applicable to this case. Apart from that, my lord, the central legislation merely prescribes minimum qualification. And it is not prohibited for the appointing authority to prescribe higher or additional qualification. There are judgments to that effect.
The law says in motor vehicles. Anyway.
Well, I'll present the judgments.
Yes.
All these arguments, Lord, is not available to the state government, having accepted the order.
My lord, I'll also
in
present,
respect of motor vehicle.
my lord, what is the,
In respect of direct recruitment, my lord, state government accepts and issues appointment order to
Lord,
33.
what is the value of a presidential value of an interim order is also decided by the Supreme Court in one case, my lord. I will also point out the presidential value is only to the,
On the presidential value. Is on your acceptance and.
Yes.
my lord, it will only bind the parties to that case. I'll present a judgment on that.
Yes. Yes. Yes, please.
Lord, section 213 of the, my lord, Motor Vehicles Act,
Yes.
1988. Lord, provides that Lord, section 213, subclause 4. Appointment of motor vehicles officer.
Yes.
4. The central government may, having regard to the objects of the act, by notification in the official gazette, prescribe the minimum qualifications which the said officers or any class thereof shall possess for being appointed as such. My Lord, kindly take, my Lord, the compilation, my Lord, which is filed today.
Yes.
Pursuant in exercise of power conferred under, my Lord, section 213 of the Act, Lord, this Ministry of Road Transport and Highways has issued this, Lord, notification, which is at page 2. This is the notification prescribed. Lord, in respect of, Lord, 254(1), Article 254(1), my Lord, your Lordship may kindly have a look at, my Lord. Inconsistency between laws made by Parliament.
Yes. Yes.
Inconsistency between laws made by Parliament and laws made by the legislatures.
Yes.
Under which entry you have found the rules?
My lord, it is under the act, my lord. It
Entry,
is under
entry.
the, my lord,
Lord, I have also
point out, my
tried to lay down, Lord, there is no entry as such, my Lord.
lord, entry 41
Concurrent-
Huh?
is to entry 41. That is the, my lord, I am referring to the judgment of the High Court, which has been interfered with by
41.
the, my lord, 40, entry 41 in list 2, my lord.
List 2 nulli. It is not in concurrent list.
My lord, what? My lord, may I just take your lordships through the High Court decision, my lord, which will be
41 is State Public Services.
state public services. The
That is
act,
not the Motor Vehicles Act.
my lord, may I just take your lordships through the judgment of the High Court.
Please, counsel, here, please tell us the basic facts.
Please. My lord, list 2, my lord, what is stated is the rules have been framed under the Karnataka Civil Services Act of 1978.
Here and there. That is not the question. Question is, what is the entry for motor vehicles, law on motor vehicles?
Motor vehicles, central legislation, I'll mention, I'll state now.
Motor vehicle ನೋಡಿದ್ದಿಲ್ಲ ನನಗೆ. ನೋಡಿದ್ದೆ.
Highways declared.
My lord, it comes under,
ಇಲ್ಲ, ಇದನ್ನ ನೋಡು. Article ನೋಡು, first starting.
my lord, entry 35 in list 3, my lord. Mechanically propelled vehicles.
Yes. Including the principles on which taxes on such vehicles are to be.
So this is not the qualification.
My lord, that is what is noticed by the division bench of this honorable court. What it says is, even on the subjects which are ancillary and subsidiary to the subject mentioned in the list, the legislature, appropriate legislature can legislate. Therefore, it has been held. In fact, the challenge was that one of the criteria prescribed for selection for appointment to the post of motor vehicle inspectors, which was experience certificate.
Whether your rule has received the present assent? Whether your rule
No.
has received present assent?
The-
Event of repugnancy?
The act has, my lord, the act has received. In fact, my lord, if I go through the judgment of the Honorable High Court, which has been interfered with by this tribunal, there will be some coherence to the matter. All these issues have been discussed. May I just take your lordships through this judgment, my lord?
Please,
If your court,
here you just a moment.
Please.
Yes.
Yes,
What is the point you want? to
yes, Lord, Lord, before that, my Lord, facts are, my Lord, my lords have heard with regard to, my Lord, facts.
Yes.
There, my Lord, the recruitment, only to refresh, my Lord, my memory, my Lord, the recruitment rules is amended. Lord, on 12/10/2022 is the amendment. which says that not 95% by direct recruitment, 5% by promotion. So the criteria for promotion is the physical standard as that of direct recruitment.
Yes.
Not the DPC was met with regard to 5% category, my lord. DPC was met on 3/1/2023. Lord, it notes that I am eligible for promotion to the post of motor vehicle inspector, but with regard to my height, DPC, my lord, disqualifies me. My lord, in respect of two persons, my lord, endorsement was issued. Lord, one against the petitioner, against Lord another. Lord,
That is also told pending
in Dharwad bench, my lord, in
Yes.
Dharwad bench. Lord, in respect of direct recruitment, Lord, the state has accepted the order, my lord, issued appointment order. And my lord, the first decision which rely upon, my lord, in
So it can be. Not yet.
Serial number 22, my lord. And accommodate 23rd of 22. Serial number 21, my lord. Kindly have it on Tuesday, my lord.
Lord, with permission of the, Lord, with permission of the court.
Yes.
Lord, matter for Monday or Tuesday, my lord, fresh matter,
My lord, serial number 27.
fresh matter. No, this is a WP case 80.
18.
My lord, serial number
18, my
20,
lord.
Yes.
27 and 30, my lord. Kindly have it next week, Monday or Tuesday, my lord. 27 and 30.
Okay, then inform.
Even in 37, sir.
35, not 37.
Yes. Please inform the other side before making.
Yes.
decisions.
Consumer 22.
ಆಫೀಸ್ ಕೆಲಸ.
Orders 2:30 PM, seal number 36. Mallikarjun C. Basit, Kashmir Halade.
These batch of matters relate to the local stand of Lokayukta in challenging the orders passed by the authorities. These,
Yes.
the I am appearing in one of the connected matters.
All these matters, the question of maintainability has been raised.
Yeah.
Question was very clear bench. That all these matters.
In some of these matters, there are office objections left to be rectified.
So it's very, we are not able to rectify because of the.
Why is it not able to be rectified? Okay, okay. Okay, therefore it's only after maintainability is cleared that the other. Yes, on the question of maintainability, should not the first respondents in these matters also be heard?
Yes, sir, they should also be. Huh?
The respondents.
Notice is ordered, I think.
In some cases, their notice is not ordered. In some cases, notice ordered is not served.
Ah.
So those issues, unless we have the other point of view also, because I'm sure the government is going to support you. Therefore, we
No,
we should
government also, we don't know what they will do.
Implemented the orders. 80 orders have been considered the government as the disciplinary authority. has
Government
implemented the
where
orders.
they have,
Even if they implement,
government,
they'll probably they'll be interested in supporting you, probably.
government blood, sometimes they have favored the employee. In such
Correct.
cases, we are,
Correct.
we are coming to court.
Correct. But then,
But where blood, the service is complete, if the matter can be heard, blood, or if in all cases notice has to.
if the common question is being considered, is it not proper that we issue notice in all the cases and hear the question after it is served?
Now, what has happened here is this, whenever we are coming to court, this issue is repeatedly cropping up. There are matters before the single judge, similar matter is before another division bench. One way or the other, if it is decided, blood. Otherwise, every day we are filing cases, we don't know, this issue is again hanging.
We'll do something, because it is the SAT matters. We'll issue emergent notice in cases where notice has not been taken out. And you can serve it on the counsel who appeared in the tribunal as well. And we'll give you a posting shortly so that we can.
One batch, your lordship, have fixed it on Monday, where the rejection of sanction is sought to be questioned by the Lokayukta. That is another slightly different matter.
So in all these cases where notice has not been ordered, issue notice to the private respondents. And the notice can be served by serving on the learned counsel appearing before the tribunal as well. Then government advocate takes notice on behalf of the official respondents. Shall we make an attempt to list this the Monday after, the week after, not Monday,
How, 22nd?
the week after? So that in the meanwhile, if you can at least serve to the council, we'll have, it is not the specific person who is important. We'd like to know it is only a pure question of law that we are considering.
Very well. What's in
Yes, the
36
week
point,
after.
36.1, my lord, sir.
Yes.
Service is complete.
Yes, you're ready?
I'm ready. I'm ready in the matter. Because my pension benefits are held up. Not the reference order was quashed by the KAT. Then against it, Lokayukta has come in a petition. Not so mainly on the ground of maintainability, my lord, sir, we want to address the honorable court.
Yes, in the other matters, maybe the respondent should be on notice before we decide the question of maintaining it. Can we have this the week after next?
Someday to Lordship, so that
Yes.
can complete the proceedings. Because one of the respondent has attained superannuation. So his pension benefits are not released because of the pendency of. Kindly consider this.
Yes. Week after next week, Wednesday. And need not be, only a short question of maintainability. The numbers need not bond box. The question is only whether it is.
24th.
22nd is a Monday.
Sorry, I'm sorry.
23rd.
24th.
Your Lordship said 26, 27th is Saturday.
No, I said 23. 23, 7.
Instead of 23, Mala, 24th. Mala.
24th.
24th better.
24.
24th.
Same 2:30, Mala, 2:30.
2:30.
Good.
Thirty-seven urgent, 38. Yes, Kalyan Basuraj.
And for the appellant,
Thanks, sir. For protection and for the steps of 1 week's time.
Issue notice on unserved R6, R10, R11 for third time.
This is listed yesterday, notified yesterday, and we are calling at 2:53. You're not even paid the process. This could have been done today morning.
We'll give you time till 5. Yes, please wait during the course of the day. Otherwise it will be stand dismissed. Yes, please.
I'm
take
appealing for
this-
the rest of the respondents, my loss in this matter.
Yes. Yes, during the course of the day.
39, Vijay Kumar.
But on IA for impleading was allowed, my lord, I have to, my lord, amend the cause title. May permitted to amend it, only one person is to be added.
Yes,
Lord, it may be called next week any day, my lord.
yes. Petition may be permitted to amend the first title list after a week.
Certainly.
Forty.
For the petitioners,
Process fee,
respondent number 2 has already been served on.
I have filed wakalat also.
you have. Yes, it is submitted by the learned counsel for the petitioner that the second respondent has been served.
ಎರಡನೇದಕ್ಕೂ ಹಾಕಿದ್ದೀನಿ ನೆನ್ನೆ.
I don't know.
ನೆನ್ನೆನೋ ಮೊನ್ನೆನೋ ಹಾಕಿದ್ದೀನಿ.
The office objection in that regard is. Yes, then.
Respondent number 1, my lords, I've already served the copies.
Second respondent, you have also been served with copies.
I appear for both 1 and 2, so.
The office objection with regard to service of copies is also overruled in view of the fact that copies have been served. Yes,
Just one submission, my lords. Respondent number 1 has filed contempt proceedings on the very same matter, which is pending, my lords, that is
973 of 2022.
22. And the outcome of that, my lords, how it is disposed of, will have effect on this, so may I request that.
is it not the other way around? Is it not the other way around?
Yes. My
Is
contempt.
it not the other way around?
This very point, contempt proceedings, they have taken the same contention. In case that is dismissed, this will not survive for consideration, my lord,
Why do you say so?
because.
So be it, then even this may be dismissed. I have no problem.
Organization, my lord, sorry.
Counsel, what is the direction of the tribunal?
Direction of this court is
Direction of this honorable court, my lords. In this review petition, your lordship,
Okay. It is a review petition. What is the direction?
that other 7, altogether 9 writ petitions have been filed by the Provident Fund Organization, my lords. And the other lots were disposed of, 7 were disposed of earlier.
Hmm.
My lords, by order dated 9th August 2021.
Hmm.
So these two were pending, these two writ petitions were pending because the respondents had not been served.
Hmm.
After they were served, my lords, this honorable court on 10th February 2022,
Hmm.
conscience will be pleased to see, was pleased to dispose of these two writ petitions
Hmm.
on the basis of the previous order.
What happened to the previous order? Was that under challenge?
Please, my lord.
Was the previous order under challenge before this court?
All 9 petitions were challenging the order in OA,
Hmm.
CAT. So the writ petitions were allowed in the first 7.
Yes.
Only these two were pending, my lords.
With regard to the other 7, did you take it up before the, you did not?
So on the court, the other 2 writ petitions were pending.
No.
7 were disposed of because the respondents had not been served. Subsequently, your lordship will be pleased to see. Learned agent clarified. Nothing further survives in these petitions. Accordingly, they stand disposed of in terms of the order dated 9/8/21.
Hmm.
So these two are also disposed of in terms of the earlier order.
Hmm.
Now, in all the writ petitions,
Hmm.
because the respondents in all the 9 had made the Union of India party.
Hmm.
So in the writ petitions also, I was constrained to make Union of India respondent number 2 as a pro forma party. The respondent number 2, no relief was sought, nothing was claimed against them. And when the learned ASG also.
What is the ground for review?
Paragraph 4 of the order says learned ASG clarified that in compliance with order dated 9/8/21,
Hmm.
the employees not in for organization section supervisor recruitment regulations 2017 will be followed. His submission is placed on record and she is satisfied. Now this fellow was causing utter confusion because he was a pro forma party. He was actually supporting the fraud and fraud organization. So this caused a lot of confusion. So in the review petition, I've stated that paragraph your lordship will be pleased to see.
Hmm.
It is submitted that the above observation of this honorable court in paragraph 4 of the order dated 10/2/22 has caused confusion, resulting in representations and grievances from candidates of various states, because this is all India repercussion, my lord. Requesting that the result of section supervisor should be revised and the eligibility should be limited to the provisions of recruitment rules of 2017. Whereas the issue before the honorable CAT and High Court had not been regarding the eligibility. Instead, it had been about preparation of the merit list, which was to be prepared as per the ETF SS LTCE scheme 2017 with single merit list, and which was upheld by the honorable court by its order dated 9/8/21. It is submitted that after the order dated 9/8/21 of the honorable High Court, the EPFO department has declared the result of the limited department competitive examination for promotion to the post of section supervisor held on 27/7/2019 in respect of 17 states on 25/1/22, wherein no legal issue was pending against declaration of the result. In fact, this honorable court in the earlier order had said that the exams were conducted by not according to the direction of the CAT, but the exams were on the very next day. So all of them were allowed to appear, all the 9 petitioners. So this, because the writ petitions were pending before this honorable court, the fraudulent organization had not declared the results. So this honorable court in the earlier order said, why have you kept it pending? Please declare the results and move on. So the results were declared, wherein no legal issue was pending against declaration of the result. The same was done by considering the eligibility of candidates as per the old rules of 1992 as amended in 2016.
Please show us the order of this court dated 9/8/21.
Yes.
Which is that? That is 9th August 2020. Yes, yes.
ಅರ್ಲಿಯ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಇದೆಯಾ ಮೇಡಮ್? ರಿಟ್ ಪಿಟಿಷನ್ ಕಾಪಿ ಏನಾದ್ರು ಇದೆಯಾ ಅಲ್ಲಿ?
I'm sorry.
I have another copy.
So this concession is made by the wrong counsel.
according to you.
Clarification can't cause confusion.
It's only the para four, my lords.
Just a moment,
It's
please.
causing confusion.
Just a moment. The recruitment rules, as already stated earlier, were notified to the official decision 5/12. Application was issued for holding limited department competitive examination on 11/12/2017. Therefore, these are the rules which are applicable. And that is found when there is a question of confusion. Otherwise, you're dealing with, statutory basis law, various vacancies. The relevant time when the rules were framed that the vacancies available. Section supervisor of the limited department of examination, therefore, is justified in notification after the rules are amended.
It is in accord.
The notification is issued after the rules are amended. The rules are amended on 5/12.
As per the order of this honorable court, they declared the result also in.
It is not the question, council. The rules were amended on 5/12/2000. Rules were notified on 5/12/2017.
That's right.
5/12/2017. Notification for holding the limited departmental competitive examinations was on 11/12/2017. Therefore, it could have been conducted only in accordance with the 5/12/2017 rules.
No, my lords. I had, in their statement of objection, what they had stated, I had filed the rejoinder, in which I had clarified, even in the review petition, my lords, it is.
Council, what you said in the rejoinder may not be relevant. What is relevant is what is stated by this court.
The only question, the only thing they had challenged in the OA was the merit list. Nowhere regarding.
Would your
the merit
lordships
list.
kindly have para 4 of the judgment? Para 4 of the earlier judgment.
Yes.
Where it was the contention of my learned friend.
Learned
that as
counsel for the
petitioner employee
Employees
from-
Provident Fund
has
Organization
argued
argued before this court that the recruitment rules governing the field known as the Employees Provident Fund rules were notified only on 5/12/17, and as many of the 13 vacancies were available for promotion under the limited departmental competence, relevant statutory provisions governing the field is contained in the schedule appended to the regulations of 2017. Aforesaid statutory provisions of law make it clear that 66 and 2/3 of the vacancies are to be filled up by promotion on the basis of seniority.
Yes.
The post of senior social security assistants.
So they said, we will follow the rules. Then in the rejoinder, they said, we will follow the rules of 2017 for preparation of merit list. We will, for eligibility, we will follow the 1992 rules and 2006. For giving promotion, we will follow the 2018 rules. I said it cannot be a potpourri of rules for promotion. You follow one. That is how it was clarified. In fact, it is their contention at para 4 that 2017 rules does not provide for year-wise vacancies. And the court said you follow 2017 rules. That is, their contention can't be that we will not follow the rules as on the date of notification.
963 or whatever, all vacancies were available, my lords.
913.
Not we had earlier for, because writ petitions were filing, were pending all over India. But here,
This petition is not in terms of this.
Hmm. If you have to,
this has been challenged before the honorable, before this honorable court in the contempt proceedings. The same.
After this order, they gave promotions following the 1992 eligibility. I have challenged it in contempt proceedings, saying that the order which was passed on 10th of February was violated by the order of promotions on 15th February. That is pending consideration. Then they filed an IA for modification which was rejected, and then this review.
Subsequent delay, my lords. Because subsequently, I had filed IA for modification of the order.
The 9821 order is under challenge, no.
No.
9821 order is not under challenge.
if
This,
anything, you must file your review against 9821 order or take it up in appeal.
These petitions have been disposed of in terms of 9821 order.
Now, they say that the government advocate has said that so and so rules will be followed.
They didn't say so, this court did.
Please.
They didn't say so, this court did.
I'm sorry. The government advocate being a pro forma, this became a writ petition, logical litigation. Union of India, because they
Who's-
had made them a party.
Who is the author of the rules?
Hello?
Who is the author of the rules? It is not the Provident Fund organization that, the recruitment rules are not made by the Provident Fund organization, they are by the Government of India.
Ministry of Labor and Employment.
It is by the ministry. They say that these are the rules to be followed. How do you say that they are only a pro forma party? They could not have made that,
But they had made them a pro forma party.
council, whoever had made them party, they are the Union of India, the author of the rules. They said that these are the rules to be followed. Now, if you have any complaint, the complaint must be against the original order, that is of 9th August 2021. Because this judgment only follows that, nothing further.
That is under challenge in the contempt proceedings.
It is not under challenge in contempt proceedings. The non-compliance is the issue in the contempt proceedings. The non-compliance with this direction is what is under issue in the contempt proceedings. How can that have any bearing?
973 of 22 is very same this way.
Madam, para number 2. In this order,
Much water has flown under the bridge. All over India.
Yes. Correct, correct,
All over
correct,
India.
correct. You agree that the matter was covered by the 9/8/21 judgment? You agree that the matter was covered by the 9/8/2021 judgment? Forget your paragraph 4. What difference does it make? You still have to, you still have to follow the 9/8/2021 judgment.
Disposed of in terms of the earlier order. Please, ma'am.
Actually, what has happened is that after 9/8/21, tribunal in Chandigarh said you follow old recruitment rules. Therefore, my lord, EPFO today rides on tribunal's judgment and says, I will follow old recruitment rules. I will not follow 2017. Whereas, my lords, here the Honorable High Court said you follow 2017 regulations. They say, my lord, we will follow 92, not 2017. That's the.
And they're facing contempt for that.
even if
No,
you
they're
say,
not, my lord, in Chandigarh, my lord, writ petition.
They're facing contempt
Contempt
here for that.
Here for that. In Chandigarh, the tribunal's judgment is stayed and it's pending in consideration. Hyderabad has disposed of following the Bangalore High Court's judgment. Jabalpur has followed Bangalore High Court's judgment. They say, my lord, no, Chandigarh is still pending there.
no, even if you say para number 4 statement is not binding on the petitioner, the consequence would be the same.
Please.
Because 9/8/21 judgment would have to be followed
Yes.
anyway.
Anyway,
Forget the paragraph 4. Makes no difference.
makes no. Therefore, my lord, it's only 2017 rules which can be followed.
It doesn't bind the petitioner. This means what binds.
That came up because that issue. That issue came up because in the rejoinder, they said, no, we'll follow old recruitment rules, not this rule.
Correct.
Then the court said, no, the scheme is as per the 2017 recruitment rules. Therefore, you follow 2017 recruitment rules. And that was clarified. That's all the issue.
Yes.
My open request is, since that is being challenged, my lords, in the contempt proceedings.
Who challenged?
Respondent number 1.
It's not a challenge, council. It is not a challenge. How is it a challenge?
Challenges. Contempt proceedings are pending. Sorry about the wrong choice. So my humble submission is, let this review petition be disposed of or heard after that, my lords.
No, it has to be vice versa.
Yes, please.
Having already-
Have you served copy of the SGI? Have you served copy of the SGI?
Yes, yes. All are represented, only 2 was not represented, my lords. Now,
I have read.
my friend represents 1 and 2.
Union of India's have 3.
There is no error on the face of this. The order 41.
Because I have only sought, my lords, in this review petition, deletion of para number 4. Because that is the main argument in the contempt proceedings. On the last date, at least that was the main argument. The learned ASG, even in their contempt petition, learned ASG. So my stand was that learned ASG was only a pro forma party.
Then
He supported the issue.
she can clarify.
Your
today
stand
which
is,
rules they
issue
will
is
follow.
covered in terms
Either-
of judgment dated 9/8/2021. That is your stand. Your stand is, issue is covered in terms of order dated 9/8/2021. That is the consequence which is noticed in para number 5. Para number 5.
We don't see anything to clarify. Unless he says so.
Correct.
Unless the ASGI, if the ASGI were before us saying that the, it is to be eschewed, that'd be a different matter.
Then, my lords, the entire earlier writ petition will have to be reheard.
No, it will
Not
not.
necessary,
It will
because
not. 9/8/2021, there is no review.
In the rejoinder, they said, no, we will not follow the 9/8/21 judgment is what they have said in the rejoinder.
No, they, in this judgment itself, we
Yes.
see paragraph.
Yes, ma'am, paragraph 2. They
Paragraph 2, the
Correct.
council says it is covered by the judgment. Therefore, that is the end of the matter. Even,
They-
no, if the ASGI were to come and say that I did not, that such recording was incorrect or whatever, there'd be something to it. How can somebody else say that?
Well, let's, today, what they want is, they want, even in the rejoinder or even in the review, they are saying we'll follow the eligibility of 92, which is impermissible. Therefore, my lord, the clarification was made saying that no, it is only the 2017 recruitment rules which are holding the field. Now, today, by deletion of that, they want to redo, my lords, the entire exercise and say, because promotions are given as per 92 eligibility.
Even without the 4th paragraph in that judgment, what would be applicable would be the 9/8/21 judgment. 9/8/21 judgment makes it clear.
Well, it's 9/8/21 according to them, my lord, says you have to follow 92 recruitment rule.
Where
That-
does it say?
My lord, I don't know. That is exactly what I was point
Where
out in
does
the
it say?
rejoinder. They said that.
that will be considered by the contempt court.
Absolutely. We don't see anything.
My lord, there was.
What do you say? Just a moment.
My lords, I appear for behalf of Shanti Bhushan, my lords. I seek for a pass over, my lords. He's on his legs, my lords.
May not be passed over. Some other day we'll.
Please.
Yes. Learned council appearing on, council appearing half of the central government council seeks time. This after.
It's going to be heard on another date, my lords. Or is it, if it's being passed over anyway?
Not passed over.
Another date, my lords, may I request a date may be fixed, because next month I'll be out of station, out of the country. If any date is fixed.
31st.
31st.
Right,
So,
ma'am.
much of that.
41, Nagarajappa.
I am for the third respondent, mail.
Beyond that, I will not take for example or not. The matter was, that is not allowed, on the ground that I am not placed in the department and record. On that count only, the order came before. Now I produced it along with the maybe remanded my lord for.
Paragraph.
Line.
Page.
Page 60, my lord.
60.
Page 60. Internal page 11. Page order. The last 3 sentences, my lord, in the page. The London government leader made the submission that the government on behalf of one and to respond to the form of party. And the London government leader as well as other party both made submission. That original records are not available. Therefore, in view of the discussion and mandate requirement of the relevant rules are not at all followed by the inquiry officer. Inquiry officer. Now I have produced my lord the entire department.
Just a moment. 11/18 inquiry authority may, after the government servant closes his case and shall if the government servant has not examined himself, generally question him on the circumstances appearing against him in evidence for the purpose of enabling the government servant to explain any circumstances appearing in the evidence against him. According to the said rule and the requirements, the inquiry officer has to prepare the question with respect of incriminating evidence appearing through the evidence of the witness examined on the side of the display authority, and inquiry officer has to read over those questionnaires to the applicant whether and whatever the answer given by the applicant, same has to be recorded in his statements, which is also not done. In order to ascertain whether those things have been followed by the inquiry officer or not, this tribunal directed the learned ground pleader as well as learned counsel for third respondent to produce original records. The learned ground pleader made submission that the government is only. Yes, now you have the original records. What do the original records disclose?
Original records now I produced along with the restriction here.
Where is it?
Along with the original record. Along with the application.
IA number.
Change in IA.
Barely
Separate file is-
not a single word in English. Yes.
I
Yes.
am for third respondent, madam.
Yes.
I am fighting for my pension since last 8 years, madam. Because of the inquiry pending before this one. So my pension benefits are prolonging, madam. My lord,
Provisional pension is being.
provisional pension I am getting, madam. The DCRG temporary pension, including my leave encashment benefit, was not been given, madam.
Correct.
My lord, the learned honorable tribunal have passed an order on the 3 grounds, madam, most important.
Yes.
That is why conducting an inquiry. The inquiry officer was not adherent to the rules followed. That is the rules 11, 14, sub-rule 14, madam, wherein he was supposed to discuss in detail the witness examined, the documents, marked, everything. So that has not been followed, madam. So the mandatory requirement was not followed. That is one, madam. Second one, my lord, as per rule 11, 18 sub-rule, wherein, my lord, the respondent, the DGO concerned should have been heard in the witness box. When she is not heard, my lord, naturally, so you have to put certain questions against whom some of the charges are, charges are going to fruit against it. So that thing has not been done. So based on these 2 grounds, and also,
Yes.
and also they have given opportunity to produce the original record in order to ascertain this. But both the government as well as the second respondent have failed to produce this record.
Now they have produced it. Now they have produced it.
No,
Does
they
it-
wanted to produce, but there is some strong objections, my lord, because when the
Please.
opportunity has been given.
Please tell us, you've seen the documents produced.
Yes, my lord.
Does it prove that you have been questioned under 1118?
No,
It does not.
no.
And specific findings on the charges are there.
Specific charges are here. madam.
Charges and specific findings on each charge.
No, madam. Inquiry report I would like to read, madam, kindly. I will just read out the inquiry report one for a while. madam. So your lordship will found in page number 29, madam. May I kindly listen. 29. The last page number 29, annex 8. May I kindly listen. Shall I read, madam? Annex ಆರೋಪ ಒಂದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ದಿನಾಂಕ
73.
Yes, madam. It is in page number 29, A2. Repetition. Paper. Even then, the inquiry report has been given. So may I read, madam?
Page?
Page number 29, madam. Oh, it's not charged. This is the inquiry.
Inquiry.
This inquiry. May I read, my lord? ಆರೋಪ 1. How they have come to the conclusion. ದಿನಾಂಕ 28/5/2005 20/10/2014 ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿದ್ದ ಅವಧಿಯಲ್ಲಿ MGNRGEY ನರೇಗಾ ಕಾರ್ಯಕ್ರಮ ಯೋಜನೆಯಡಿಯಲ್ಲಿ ಹುಲ್ಲೇಕೆರೆ ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ವ್ಯಾಪ್ತಿಯ ಜಕ್ಕನಹಳ್ಳಿ ಗ್ರಾಮದಲ್ಲಿ LPS ಶಾಲೆ ಆವರಣದಲ್ಲಿ ಮೈದಾನ ಅಭಿವೃದ್ಧಿ ಕಾಮಗಾರಿಯು ಅಂದಾಜು ಮೊತ್ತ 2 ಲಕ್ಷ ರೂಗಳಿಗೆ ಮಂಜೂರಾಗಿರುತ್ತದೆ. ಕಾಮಗಾರಿ ಅಂದಾಜು ಪಟ್ಟಿಯಲ್ಲಿ 49 ಮೀಟರ್ ಉದ್ದ, 0.23 ಮೀಟರ್ ಅಗಲ ಮತ್ತು 1.2 ಮೀಟರ್ ಎತ್ತರದ ಕಾಂಪೌಂಡ್ ನಿರ್ಮಿಸಲು ಉದ್ದೇಶಿಸಿದ್ದು ಸಿಮೆಂಟ್ ಪಾಯಿಂಟಿಂಗ್ ಮಾಡಿಲ್ಲದಿದ್ದರೂ ಅಳತೆ ಪುಸ್ತಕದಲ್ಲಿ ಮಾಡಿರುವುದಾಗಿ ಬರೆಯಲಾಗಿದೆ.
What is pointing? What is pointing?
My lord? Painting, cement painting.
All right.
ಇಲ್ಲದಿದ್ದರೂ ಇಲ್ಲಿ ಪಾಯಿಂಟಿಂಗ್ ಅಂತ ಬರ್ತದೆ. ಶ್ರದ್ಧೆಯ ಮೇಲೆ ದಿನಾಂಕ 28/5/2005 20/2005 ಅವಧಿಯಲ್ಲಿ ಉಲ್ಲೇಖೆರೆ ಗ್ರಾಮ ಪಂಚಾಯತಿ ವ್ಯಾಪ್ತಿ ಜಕ್ರಳ್ಳಿ ಗ್ರಾಮದಲ್ಲಿ LPS ಶಾಲೆ ಆವರಣದಲ್ಲಿ ಮೈದಾನ ಅಭಿವೃದ್ಧಿ ಕಾಮಗಾರಿಯ ಪೂರ್ಣಗೊಂಡಿರುವ ಬಗ್ಗೆ ಅಳತೆ ಪುಸ್ತಕದಲ್ಲಿ ದಾಖಲಿಸಿರುವ ಬಗ್ಗೆ ಸಿಮೆಂಟ್ ಪಾಯಿಂಟಿಂಗ್ ಮಾಡಿಲ್ಲ, ಆದರೆ ಅಳತೆ ಪುಸ್ತಕದಲ್ಲಿ ನಮೂದು ಮಾಡಲಾಗಿದೆ ಎಂದು ಗಣನಿಯಂತ್ರಣ ಮಾನಿಟರ್ ಅವರ ದಿನಾಂಕ 21/5/24 ವರದಿಯಲ್ಲಿ ಹಾಗೂ ಪರಿಶೀಲನಾಧಿಕಾರಿಗಳು ವರದಿಯು ಮಾಡಿದ್ದು, ಇದನ್ನು ವಿರೋಧಿಸಿ ಆರೋಪಿತ ಸರ್ಕಾರಿ ನೌಕರರು ಯಾವುದೇ ದಾಖಲೆ ಸಲ್ಲಿಸದ ಕಾರಣ ಈ ಆರೋಪವು ಸಾಬೀತಾಗಿದೆ ಎಂದು ಅಭಿಪ್ರಾಯಪಡುತ್ತೇನೆ. My lord, here the relevant documents have not been marked here. The witness was not examined here. So based on the report given by one Parishalanadhikari, so they come to conclusion that the charges are true. This is not so. This is not permissible under CCA rules.
Inquiry report.
This is my lord.
Government is.
This is the inquiry report.
Government is formal party here.
Who has conducted
This is the
this
Jilla
inquiry?
Panchayat petition.
Just a moment. Who has conducted the inquiry?
Principal. Petitioner is conducted then.
District training school principal.
How can you conduct an inquiry like this? You say what the charge is, and then you repeat that that charge is proved. On what material? They are also governed by the CCA rules.
Yes, ma'am. Yes, ma'am.
11, 11, 14. 11, 18, 11, 11, 18.
The material being in your files is not enough. It has to be discussed in the inquiry. Delinquent employee, have you admitted the charges against you?
No, no, I denied. I denied and during the inquiry, subsequently they have issued a show cause notice,
There
thereafter
is,
denied.
is there the charge memo was served on you?
Yes, my lord.
You submitted your reply.
Yes, ma'am.
Where is that reply, please?
So page number 35, annexure A4 is the reply filed by me with regard to second show cause notice, my lord.
That is not the question.
Charge memo.
Where is your reply to the charge memo? It's only if you deny that you have to be given an opportunity
Yes.
in the inquiry. Where is your denial as against the charge memo?
I could not able to find it here, my lord, but I am going to produce it. Give me a small time, madam, I am going to produce.
Therefore, it has to be considered. If, because it appears that the inquiry proceeds on the basis that you. If you did not deny, they don't have to prove it.
No, I have denied them. All along I have been denying them. All along. Even.
What is your pleading before the tribunal?
Pleading.
This page, Solomon.
Next. Full complaint.
Response to the said charge memo, the applicant had filed detailed statement of objection, denied the charges. Thereafter, there also you did not produce. A joint departmental inquiry was conducted. Inquiry was conducted and submitted a report, annexure A2. Thereafter, third respondent issued second show cause notice. That is not the question. To the charge memo, did you submit an objection denying the charges? If it is not there, they don't have to hold any of this.
I have submitted. Based on that only. the
It's not
inquiry
produced
was
before the
conducted.
tribunal.
If we not placed before the tribunal, my lord,
It's
it
not-
is a matter
not
of
before the tribunal.
remand.
The reason, my lord.
Can you just take a look into the copies of the reports? Because we should have a box of the judgment. The STP, the
When did you file reply?
My lord, for the second show cause notice, I
No, no.
filed
To the charge memo, to the charge
Please
memo.
don't harp on the
Sir,
second
the
show
records
cause.
not all available, my lord, I am going to produce my. Because.
It is not forthcoming.
My lord, after. By framing this. My lord, after my denial only, the inquiry has hold, my lord.
That submission will not do.
Yes.
You must produce the
Denial
the
report.
denial, unless you have denied. Or if you, even before the inquiry, once the inquiry starts, if you go there and say, I don't have any contentions, they can proceed on the basis of that. Nothing wrong. Unless you show that there was denial.
The officer says, instead of searching the records, based on the records, and arrive at this conclusion. In addition to that, it's not denied.
Because in the inquiry process, it is not that it is very new. You can probably, what do you say about sending it back instead of this hanging fire here? You can produce your denial, because this says that the inquiry report at least says that you did not deny. So if you did deny, produce it before the,
Yes.
even if it is denied. I mean, even if it is, if they are not relying on anything, that must be put to you, we understand. But if you say that you do not deny, or if you raise your contentions only on other aspects, without denying the factual facts which led to the charge, then probably this was justified, we don't know. Shall we send it back? You can produce your denial also there.
Moreover, my lord, another important contest that I have taken, my lord. The third respondent, after my retirement, the third respondent has filed a penalty order against me. So he is not the competent authority to do that, because after my retirement, it is the government is going to be competent authority to do that. So based on that, I have also continued, my lord, that was taken. So as per 2142 of the cases are, my lord.
That can be set right.
Yes.
If the inquiry is proper, that probably can be set right.
So I have challenged the inquiry penalty order based on that. On this ground also, the KT set aside the order subject to inquiry report. The penalty order may.
Where is the
He is not the
finding?
competent authority to do so.
Where is the finding as
That
to?
is page number 50 more, but kindly be seen.
50?
53. 54, but kindly be seen. 54.
Citation.
So there's a citation starts from 53, my lord. The citations, I would like to read them. Therefore, the impugn order is not a speaking order and it is passed in contravention of decisions rendered by
Just a moment, counsel. That is your contention.
Yes, this is my contention.
It is only your contention. Where is the finding?
ಇದೇನೆ
Finding in law. It is not found in the finding. That was the contentions that I made before the.
Only recorded the contention, there is no content. Or if at all, they say that you have not denied specifically, then also you can urge the other contention that the penalty is passed by incompetent authority. 214,
2142. A. A.
yes, yes.
2142A. So provision has to be. Married Miller? Yes. The department.
Yes. After retirement, it has to be submitted to the government and the government has to pass the.
Yes.
So being the matter, my lordship, the application itself, my lordship, premature.
Why do you say so?
Because my lordship, that he is not approach the government against that punishment order.
Why should he?
No, that is the provision is there, my lordship, under the against.
Maybe there, but if the contention is that the wrong authority has passed the order, then why should he wait for the appeal to be over?
Against that
The preliminary contention that you have to meet. He is retired from service, after which the penalty order has been imposed. It could have been imposed only by the government.
Against which, my lordship, appeal is available in the government.
It is not a bar for invoking the power of judicial review.
For my lord, before retirement.
Initiation taken place, but please see 214A proviso. Even if it is taken place before he retires, after his retirement, if the punishment has to be imposed, the report has to be preferred before the government. Or was it after?
My lord, penalty order 26/4/2021, my lord. I retired on 30/9/2016, my lord. The charge memo has been issued on 26/4/2016, my lord. But final report, penalty order is 26/4/2021, my lord, after my retirement. After 5 years of my retirement almost.
What is the material on which you say that he admitted? You have now produced the files. Where is the material to say? Then what is the point in remanding it? Then what is the purpose in remanding it? Please produce the reply.
Yes.
Please produce your reply and something to show that it has been properly served on them in the inquiry proceedings. If you did not reply, then probably we'll have to assume that you did not have any, or we'll have to consider what the materials that they have produced now.
No, actually, these articles of transfer level against pay only with reference to a Manrega program. That is a scheme implemented by the Gram Panchayati to provide employment to the unskilled workers of the village. So wherein I am not the direct.
It is not the Gram Panchayat which has implemented the program. It is a national government program, central government program.
The ground level Gram Panchayat is being implemented.
Correct, correct. The implementing authority was the Gram Panchayat.
Yes, madam. I am attached to Taluk Panchayat. I was simply looking after only this work there. So thereby whatever the charges they have made, they are not actually, they are.
We cannot, the facts of the charges and what the findings are, those are not things that we can. The only question is, did you deny the charges? If you did not deny the charges, then what was the purpose of them there? Yes, please produce these materials. On what material do you say that he did not deny? If he gave, otherwise why, what is the need for an inquiry? If he did not deny at all, what is the purpose for an inquiry? If he kept quiet also, you have to prove it. If he did not say anything also, you have to prove that it has happened. You cannot say that he has then what is the material on which you relied, it will be relevant. Yes. Learned. Still appearing for the petitioner seeks time to produce the reply he had submitted to the charge memo. Dated, what is the date of the charge memo?
Date of charge memo is my lord 26/4/2016, my lord.
Charge memo dated 26/4/2016. List after 2 weeks?
Oh,
Yes, translations may also be necessary. Relevant records, translations may be necessary. Shall remain in force till then.
because of the interim order that my contempt proceedings is kept in
That is all,
abeyance.
that is all.
Date. 42,
Date,
Take them up.
date,
31st.
31st.
This is relating to selection and appointment to the post of motor vehicle inspector, my lord, denial on the ground, he did not have the prescribed height. Lord, I have served on the one, Siddharth Baburam, my lord, for, second respondent. Lord, his name may be shown in the first file.
You sure? Is this direct recruitment?
Yes,
Promotion.
yes, direct.
Yes, ma'am.
Would you appear for?
I'm appearing for Siddharth Baburam.
You want?
Name is not
Second.
shown, my lord. I have requested, them to appear in the
Show the name of the learned counsel appearing for the
second respondent.
second. List on.
Is being heard, today, my lord, the matter is passed over. Just wanted, yes.
14, connected.
Yes,
This case does not involve the question of,
they've challenged it.
This is directly involved.
Direct
they have not challenged the, on the ground of the rule not having, the central government rule being in variance with the state government rule.
That
It is
we-
not the ground taken here.
We'll consider it
Please.
separately.
Reporting settlements, number 43, SV Prakash.
My lord, I am for the appellant. Regarding settlement, I have not received any information from my party. Hence it may be
My
raised.
senior is unwell, he's hospitalized. Trying to put it on Monday, your lordship, will be.
There is no question of arguing when a matter is posted for reporting settlement.
I'm not.
Please
aware
come
of
to the
this.
settlement among yourselves and tell us. We'll only record it.
I'm not aware of the case at all, your lordship.
No
Who
information.
made a statement that the matter is going to be settled?
It is my colleague had submitted, my lord, at the first instance. Thereafter, FDP is already filed by the defendants, that is the present respondents. It was instructed that in the FDP, it would be settling the matter amongst amicably. But
It is not yet concluded.
not concluded and not informed, my lord.
Verify from the website.
It is pending. Matter is pending.
Do you require any assistance from the mediation center for settlement of your disputes?
My lord, it was told to us that amicably they are settling.
Exactly.
That's all.
If you want any impetus to amicably settle, we can,
I'll get the instructions and if it is possible, my lord, either at their place or at Bangalore, which one is convenient, I will say.
yes. It is submitted by the learned counsel appearing on either side. That the matter is not as yet settled. Just the above view of the matter. The parties are at liberty to mention the matter for bringing up in case any settlement is arrived at. List in the usual course.
And interim order may grant.
Was it there earlier? No.
No, it wasn't.
Final degree proceeding is stayed.
2020.
There is no interim order.
Well,
There is no interim order.
it is there.
It is.
Time to time it is there.
Till when?
49 ಅಲ್ಲಿ ಇದು ನೋಡಿ extend ಆಗ್ತದೆ.
No interim order.
That is on 16th June 2023, my lord. I number 1 of 22 is disposed of, interim order as prayed for. I number 1 of 2022 is disposed of, colon.
Interim order as prayed for.
What is this?
Yes.
FDP.
We will permit the final decree proceeding to
Yes.
go ahead. Only final decree be strong, drawing of final decree.
Yes, that's,
Suit for partition decreed, right?
yes, my
For
lord.
partition.
Some properties were left.
Yes, it is submitted that the suit for partition is decreed and the defendant is in appeal. Full stop. The final decree proceeding is already initiated. All proceedings can proceed further except drawing of final decree.
Okay.
For disposal, 230, seal number 49.
But the age is held up today, madam. It's tested for adjournment. We have informed the other side. ಹೇಳಿಲ್ವಾ?
When do you want it?
There are several of them. One of my colleagues was informing everyone.
Yes.
Already any date. convenient
Therefore,
to this honorable.
let's not a disagreement as to whether the other side was informed or not. When do you want it?
I have been informed.
You've been informed. You are sailing along with them. That's why you've been informed. Yes. When?
But any date convenient to this, any early date.
Not next week, the week after that. Not next week. Next week we have packed. 25?
Please.
Yes.
Shifts can give slot of Tuesday or Thursday, so that we can.
Coming Tuesday, Thursday. So many matters that are part-heard are being posted. Including this. Including this.
You partnered in that.
You know,
One matter I may not appear.
Thursday. Thursday, how many matters are there?
I told them what the.
Quite a few. Hmm? This is also for the hearing matter. But not for. Not part-heard, at least officially not part. The officially part-heard matters itself, there are quite a few. We'd like to try and finish those off. We'll list it the week after, 25th
This is also not part.
is maybe part-heard, but at least not
Yes.
mentioned as part-heard. Those matters we have to get disposed of, otherwise it will create problems.
For the guy, I don't know whether the additional.
That is, it is for,
This
That-
matter may not take much time.
no, the additional advocate general wants to address. And
OM is only a supplemental to the earlier two GOs.
I understand.
Without affecting both the groups. That's the point. It doesn't deal with quota.
Anyway, let us see, that is the contention that you have. We'll anyway hear them.
That in my counter before the tribunal, my lord, I have stated.
According to you, it does not infringe on either the rules or the quota.
In fact,
is
what
only-
happened? After Gonal Bhima Pass case, my lord, Adami's case, the 5/7/1976 GO had been issued. How the quota has to be worked out. And if the promotions has taken place between both the groups, how the seniority will have to be arranged, taking into consideration the block periods. Every amendment, one block, every director treatment, another block. This is the structure. Then Gonal Bhimappa has reiterated the position. Then, my lord, when the law is changed, DR will only get the seniority from the date of the substantive appointment.
It is the law. That has always been the law.
So far as the promotee is concerned, they will get, unless the rule provides a retrospective promotion. There are 3-4 circumstances under the Karnataka 78 rule.
They will get either the date
Field
of their
cover,
promotion.
criminal case.
No, they will get either their date of promotion or the date on which and vacancy becomes available in their quota.
In their quota.
That's it. That's the one.
But they can't go back even if it is there in their quota unless and until the promotion, the consideration is under the sealed cover, criminal case or disease. That is how retrospective can give us. When this is the position, in view of the direct recruitment Maharashtra's case, when a quota rule is broken, seniority is linked with the quota.
When
If
for
it
the-
is broken,
For the quota rule to be broken down,
if it is the,
must be
1 year
short
is the limitation, Apex Court said 1 year is the limitation. In the instant case, there is a long gap of DR. Therefore, if seniority is linked with the quota, the constitution bench said, if quota is broken, seniority also will broke. Then you can only give life to prepare a seniority list by some mechanism by the government. Apex Court said it is for the state government. Now, if both the vacancies, if quota could not be done, the seniority cannot be counted, it cannot be assigned to anybody. So therefore, this circular says vacancies from both the groups would lapse. And
The other group is 0. Promotion quota is 0. It's only the direct recruit vacancy has been lapsed.
I am not arguing for my case. I am informing to the court.
Please.
Clause 4 of the GO dated 23/3/2006, lapsing of the vacancies for the DR on a particular date, lapsing of the vacancies for a promoter is it applies to both the group. Then, my lord, whatever the vacancies which have been lapsed will not be taken into consideration, but the posts available to both the quotas will start afresh. This is how, my lord, if the quota rule is broken, the state government has. Now, all that the prayer in the petition was, one is the provisional list to be finalized, quashed. That can't be done. Second is the seniority list has to be done based on the vacancies. In fact, the seniority will be determined based on the cadre strength, that is the post. It cannot be on the basis of the vacancies. This is what Sabharwal says. This is what, my lord, the constitution bench also. So there, the prayer is, you prepare, issue a writ of mandamus to prepare a seniority based on the vacancies. There cannot be any vacancies in the seniority. Seniority is linked with only the post, the number of posts, and on the cadre, not on the vacancies. This is how, my lord, the para 6 of the constitution bench Sabharwal. So therefore, both these, how do they affect it? It doesn't deal with the quota rule. It only
Consider.
supplements the working of 2 government orders earlier, 76 and 77. If this GO is not there, if quota is broken, seniority you can't assign because the quota is broken, then how do you work it out, prepare a seniority list?
then we
This
have to
gives a
examine
life.
the question of breaking down of the quota rule as provided by the Supreme Court in Maharashtra Engineers Association. There, for breakdown of the quota rule, it is not enough to say that the appointments have not been made for a specified time.
Yes, it is open to a lawsuit whether the power has been exercised mala fide or not.
Whether the power has been exercised at all would be the.
Yes, that was also, my lord, in the Delhi case,
Yes.
2000, where even though the court said quota rule is broken, whether the quota rule is broken or not, if it is mala fide, para 79 says, court can exercise the power. But actual appointments were made in 17. They were not there when the OM was issued 23/3/2016. The appointments was only in September 2017. By that time, these promoters have been already given a promotion under Rule 32. And subsequently, they have been regulated in 16 itself. So therefore, we became, within our quota, we have been regularized, 2016. Then these people came born in the cadre in 17. Like in view of Jammu and Kashmir, that constitution bench, they don't have locus to challenge this OM. That's it.
Nilkant. Yes. Sorry. What do we do with the first appeals? Commercial appeals and first appeals. It is only to, it is also to give them what, at least one clear day that we understand. Because the service matters, parties appear to be more ready with the arguments also. They are shorter matters, we can hear it in a short time, but that does not on Monday.
After matters, number 14.
Yes, Motor Vehicles Act. First tell us what the Constitution says, then tell us what the Motor Vehicles Act says.
Please.
Yes.
Inconsistency between laws made by the parliament and laws made by the legislatures of the states. If any provision of a law made by the legislature of a state is repugnant to any provision of law made by the parliament, which parliament is competent to enact, or to any provision of an existing law with respect to one of the matters enumerated in the concurrent list, then subject to provisions of clause 2, the law made by the parliament, whether passed before or after the law made by the legislature of such state, or as the case may be, the existing law shall prevail, and law made by the legislature of the state shall, to the extent of repugnancy, be void. 2. Where a law made by the legislature of a state with respect to one of the matters enumerated in the concurrent list contains any provision repugnant to the provisions of an earlier law made by the parliament or an existing law with respect to that matter, then the law so made by the legislature of such state shall, if it has been reserved for the consideration of the president and has received his assent, prevail in the state.
Yes.
Provided that nothing in this clause shall prevent Parliament from enacting at any time any law with respect to the same matter, including a law adding to, amending, varying, or repealing the law so made by the legislature of the state. My lord, admittedly, my lord, the recruitment rules framed by the state government at Annexure A1 is, my lord, invoking Section 3 and 8 of the Civil Services Act. But therefore, my lord, the height is not prescribed in the admitted position is, my lord, height is not prescribed in the, my lord, central rules. But with regard to the similar provision, but I showed your lordships with regard to, my lord, the qualification prescribed, not invoking Section 213 of the Motor Vehicles Act. Not yes, 213, subclause 4 empowers, my lord, central government to
Is it your case that the state government has no power to enact this issue?
But I cannot say that, my lord, state has no power. State has power, my lord, to regulate the service condition of,
Should not be repugnant to any specific state in the Motor Vehicles Act with regard to a post which is governed by the provisions of the Motor Vehicles Act.
but state government, my lord, my lord, I cannot contend that, my lord, the state government cannot, my lord, regulate, my lord, enact the
Conditions.
service. Yes,
Service conditions is perfectly within their
state government
competence.
is clothed with the power to regulate the service condition and, my lord, prescribe qualification. There is no quarrel about. But it cannot be contrary to, my lord, the central level.
Thus, there is a precedent assent.
Please, yes, unless, my lord, the admit
Actual assent will have to be obtained to that specific rule.
rule. Yes, with reference to a particular rule, my lord, they have to take assent. But, Lord, with reference to Motor Vehicles Act itself, Lord, the provisions are, my lord, considered by the Honorable Apex Court and says that, my lord, where there is the provision which is repugnant is void with reference to, my lord, Motor Vehicles Act itself. Lord, may I request my lords to have, my lord, the list of citation. And page
Therefore, it becomes occupied field. Theory of occupied field.
yes, the theory of occupied field is discussed, my lord, at page 8. Lord, I will not trouble my lords reading the entire, only the relevant portion, my lord. Page 8,
Of,
Lord, today's compilation, my lord.
yes,
First document is, my lord, the notification issued by this Ministry of Road Transport and Highways.
yes, yes.
There, my lord, height is not prescribed.
Hmm.
Page 2, my lord, before that, page 2 is the notification issued
Hmm.
by the Ministry of Road Transport. Height is not prescribed.
Hmm.
These are all, my lord, admitted position which my learned friend may not dispute. The first decision is, my lord, page 8. Page 8, my lord, at para 12, last sentence, my lord. The position that is that under the Constitution, Parliament can, acting under proviso to Article 254(2), repeal a state law, but where it does not expressly do so, even then state law will be void under that provision if it conflicts with the later law with respect to the same matter that may be enacted by Parliament. In the present case, there was no express repeal of Bombay Act 52 of 1950 in terms of proviso to Article 254(2). Then only question to be decided is whether the amendments made to so and so Act by the Central Legislature 1948 are further legislation falling within the section 107 of Government of India Act or law with respect to the same matter falling within Article 254(2). The important thing to consider with reference to this provision is whether the legislation is in respect of the same matter. If the later legislation deals not with the matters which formed the subject of the earlier legislation, but with other and distinct matters, though of a cognate and allied character, then Article 254(2) will have no application. The principle embodied in section 107(2) and 252 is that when there is legislation covering the same ground, both by the center and by province, both of them being competent to enact the law of the center should prevail over that of state.
Therefore, it does not matter under what provision the state law was enacted.
Yes.
It can be 309, it can
309
be anything else.
And
Whatever that be, if there is a
yes,
specific law on the very same subject
yes,
by the center, then the state law goes.
yes.
Yes.
Not the second decision, my lord,
Hmm.
page 12. Not coincident is, my lord, there is a conflict between my lord, UP Transport Act 1955 and my lord, Motor Vehicles Act with respect to the provision of Motor Vehicle Act, not para 2.
Yes.
It is not a split decision, my lord. The other judge also concurs with the majority view, but different judgments are written. Para 2, my lord. The relevant facts and several points raised by the learned counsel for the appellants and petitioners in support of the appeals have been fully set out in the judgment which our so-and-so presently deliver, and it is not necessary for us to set out the same here. Without committing ourselves to all the reasons adopted by so-and-so, we agree with the following conclusion, that the Uttar Pradesh Transport Service Act so-and-so hereinafter referred to as UP Act did not, on passing of Motor Vehicle Act 1956, hereinafter referred to as Central Act, become wholly void under 254(1) of the Constitution, but continued to be valid and subsisting law supporting the scheme already framed under UP, that even if the Central Act to be construed as amounting under Article 254(2) to repeal UP Act, such repeal did not destroy or efface the scheme already framed under the UP Act for the provisions of the scheme of Section 6 of the General Clauses Act saved the same, that the UP Act did not offend the provisions of 31 of the Constitution as it stood so-and-so for the UP Act, and in particular, Section 11(5) thereof provided for payment of adequate compensation. These findings are quite sufficient to dispose of the points urged by so-and-so in support of the claims and contentions of the respective clients. Not the other judgment starts with, my lord, para 14, page 14.
Yes, para 5.
Yes, the relevant page. Occupied field is, my lord, discussed. But page 35, my lord. When there is a lord, conflict, page 35, last paragraph.
Yes.
Article 254(1) lays down a general rule. Clause 2 is an exception to that article, and proviso qualifies the exception. If there is repugnancy between the law made by the state and that made by the parliament with respect to one of the matters enumerated in the concurrent list, the law made by the parliament shall prevail to the extent of repugnancy, and law made by the state shall, to the extent of such repugnancy, be void. Under clause 2, if the legislature of a state makes a provision repugnant to the provisions of the law made by the parliament, it would prevail if the legislation of the state received the assent of the president. Your lordship may kindly mark. Only, my lord, when assent of the president is obtained,
Yes.
that will prevail. That is the observation at, my lord, page 36.
Yes.
Even in such case, Parliament may subsequently either amend, vary, or repeal the law made by the legislature of the state. But even after taking the assent, but Parliament can amend the.
Can. Yes.
In the present case, so and so, that is on present case, my lord. Para 28, there may be inconsistency in the actual terms of the competing statutes, though there may be no direct conflict. A state law may be inoperative because the Commonwealth law or the award of the Commonwealth Court is intended to be a complete exhaustive code. Then, my lord, at page 36, my lord, repugnancy between two statutes may thus be ascertained on the basis of following three principles. My lords got it. Whether there is direct conflict between two provisions, whether Parliament intended to lay down an exhaustive code in respect of the subject matter, replacing the act of the state legislature, whether the law made by the parliament and law made by the state legislature occupies the same field. Then, my lord, with reference to, my lord, occupied field, page 40, it is therefore, my lord, at page 40, my lord, before para 31, last, my lord, 5 lines, with reference to occupied field.
It is therefore.
It is therefore, yes, my lord. It is therefore manifest that amending act occupies the same field in respect of schemes initiated after amending the act. Therefore, to that extent, the state act must yield its place to the central act. But the same cannot be said to be the schemes framed under UP Act before amending the act came into force. Then, my lord, paragraph 31, last 3 lines. Therefore, under Article 254(1), the law of the UP Act subsists to support the scheme framed thereunder. It becomes void only in respect of schemes framed under the Central Act. Then, my lord, page 42. The said observation directly applies to a situation created under Article 254(1).
Yes.
Then, my lord, the third decision is, my lord, page 53. M. Karunanidhi versus Union of India and another. Lord, page 69.
Yes.
Again, my lord, they say, reiterate that occupied field, inconsistency and conflict.
Yes.
And I will not read, my lord, para 24. It is somewhat, my lord, reiteration of the
Yes.
page 74, para 35. It says that the state act has to yield. That's all, my lord. With reference to the present case, my lord, their direct recruitment and promotion is governed under one rule, one common rule. 95%.
Yes.
95%, my lord, by direct recruitment, 5% by promotion. In respect of direct recruitment, Lord, state government accepts the order of the, my lord, though it is an interim order. I am not saying that, my lord, final order is passed. Though it is an interim order, state has accepted it. Lord, board is constituted. Board is constituted. They were asked to appear for medical test, except their height. Lord, in respect of 6 persons, they did not, my lord, issue an appointment order since they did not satisfy the other criteria. In respect of 33, my lord, without reference to the height, they are appointed. In fact, my lord, I am told that, my lord, file is moved for declaration of their probation.
Yes.
Therefore, my lord, state cannot say that, my lord, for direct recruitment, I will accept, in a particular case, I will accept it. For, my lord, a specious endorsement is issued, that, my lord, I am bound by the Supreme Court order in respect of a particular case. In your case, I will not. That may not be, my lord.
Yes. Yes, what was the judgment you wanted to refer to?
My lord, I wanted to draw your lordship's attention to the writ petition from which the SLP has originated. My lord.
Which SLP?
The writ petition.
The present SLP.
Yes, ma'am. The SLP in which the interim order has been passed based on the beneficiaries.
It is available?
I have. The petitioner is seeking parity with the beneficiaries of the interim order. Many of the questions your lordship posed are answered here, particularly relating to the assent of the president. And in fact, it has been held in their favor on the point.
It is a complete code. Everything with regard to how every such officer shall be integrated. So we may make rules to regulate the discharge by officers of the department. And in particular, without the prescribed uniform to be performed by them. Authorities which they shall be duties to be performed by them. Powers including provide exercise by police officers and to be exercised by on the conditions governing the exercise. Then, central government, having regard to the objects of it, by notification to officials, this is the article. This is the article. One step is on exactly the same point. And this there is a discipline. It is here specifically there is a protection with their permission. The protection describe the qualification specifically is and the only side is the question is then reproducing which way this is the architecture. There is a reproduction. Yes.
In fact, there were several repetitions on several issues for communication for talent. One of the issues was that the central legislation prescribed the criteria of experience, which was not prescribed in that of the state, and therefore they were repugnant. And in that respect, those who were selected had to be, their selection was to be quashed, and that was accepted by the tribunal and it was quashed. That is what is noticed in the first paragraph. Page 88. Come to paragraph 2, by the aforesaid recruitment notification, the Karnataka Public Service Commission had called for applications for the post of motor vehicle inspectors. The administrative tribunal by the Interim order has quashed the recruitment notification, the appointments made pursuant thereto, on the ground that the recruitment notification did not stipulate one of the minimum qualifications prescribed by the central government for the post of motor vehicle inspectors, namely work experience of at least 1 year in a reputed automobile workshop. This is one of the minimum qualifications prescribed by the central government. As per the notification dated 19/6/1989 in exercise of the power under section 213(4) of the Motor Vehicles Act of 1988. The issues are maybe kindly noticed, my lord. I'll just take you lordships to the very first issue.
Yes.
Whether the qualification prescribed for the post of motor vehicle inspectors by the Karnataka General Services Motor Vehicles Branch Recruitment Rules 1976 as amended by the Government of Karnataka by notification dated 24th November 2005 in exercise of the powers under subsection 1 of section 3 of rule read with section 8 of the Karnataka State Civil Services Act of 1978 would override the minimum qualification prescribed by the central government by notification dated 19/6/1989 in exercise of the power under section 213 subsection 4 of the Motor Vehicles Act of 19. Well, this is the only relevant.
Yes.
But the answer can be found at page 95. Regarding question 1 and 2, as stated above, the administrative tribunal has set aside the recruitment notification. Your Lordship has it.
Yes.
Page 95.
Hmm.
Recruitment notification dated 18/8/2006 and also the appointments of motor vehicle inspectors made pursuant thereto on the ground that the recruitment notification did not stipulate one of the minimum qualification prescribed by the central government for the post of motor vehicle inspectors under subsection 4 of section 213 of the Motor Vehicles Act of 1988.
Hmm.
It also relied on the judgment of the Supreme Court in Satyapal Reddy versus Government of AP.
Hmm.
The controversy in these writ petitions is whether the quashing of the appointments of motor vehicle inspectors by the administrative tribunal by its order dated 25th May 2010 on the aforesaid ground is correct in law.
Hmm.
The contention urged is that notwithstanding, this is by the government,
Hmm.
the qualification prescribed by the central government in
Hmm.
exercise of the powers under section 213(4) of the Motor Vehicles Act of 1988, the state has absolute freedom to prescribe qualification for the post of motor vehicle inspectors in view of the Karnataka State Civil Services Act 1978, whose subject matter is relatable to entry 41, list 2, state list of the 7th schedule of the Constitution, namely the state public services. In view of the qualification prescribed for the post of motor vehicle inspectors by the recruitment rules framed by the Government of Karnataka in exercise of the powers under subsection 1 of section 3, read with section 8 of the Karnataka Civil Services Act of 1978.
Hmm.
It was contended that the minimum qualification prescribed by the central government for the, this is the point I'm relying on. It is contended that the minimum qualification prescribed by the central government for the said post in exercise of the powers under subsection 4 of section 213 of the Motor Vehicles Act 1988 will not apply to the state government. It is also contended that the State Civil Services Act of 1978, having had received the assent of the President, has an overriding effect on section 213 subsection 4 of the Motor Vehicles Act of 1980.
No.
No, it has not been accepted, madam.
Yes.
It is in their favor. I'm not.
Yes.
My lord, what I'm saying is, on this point, in fact, the court has held that the central legislation will prevail.
No, we are on a, I understand the contention.
Yes.
But just let us remind you
Please.
that 214 is a provision which says that for the purpose of carrying out the provisions of the Motor Vehicles Act, each state is free to form its own motor vehicles department
Yes, ma'am.
to make appointments there, to provide for the functions of the motor vehicles inspectors, etc. All that you can have. As far as qualifications are concerned,
Yes.
213(4) specifically says that the central government shall prescribe the qualification,
Prescribe minimum qualification.
prescribe the minimum qualification. Therefore, once that prescription of the minimum qualification is done by the central government, anything repugnant thereto in the state rules.
That is the question that I'm posing to myself, my lord.
Yes.
Whether there is repugnancy, because we have adopted the minimum qualification. Only thing we have done is we have prescribed something higher, something additional. That has been held to be, my lord, I'll refer to Satyapal's case, which was referred to earlier, my lord. That is
1978 rules.
If there was something residual left for you to do, you could have done. That
Because when they say
234
minimum,
does
my lord.
not leave any residual power
My lord,
in the state government to prescribe qualification.
It will become very clear, my lord,
Yes.
when the judgment is,
Yes,
No.
I don't know why both of you are not referring to, there is a covered judgment by the Supreme Court
I have, my
on
lord.
the specific.
I have
point.
the judgments.
It comes from Kerala. There is a covered judgment. Yes, anyway.
My lord, Satyapal's Reddy's case was sought to be distinguished. I'll not read. Before, my lord, in fact, Satyapal Reddy's case was sought to be distinguished as not applicable. But in my case, I'm actually relying on Satyapal Reddy's case.
Paragraph 18.
My lord, the
15
central
of
government, this one, so is notice, my lords.
Hmm.
And thereafter, your lordships may kindly notice at page 99,
Hmm.
the section 213.
Hmm.
But I will only read sub rule 4, my lord.
Hmm.
At page 99.
Hmm.
The central government may having regard to the objects of the act by notification in the official gazette, prescribe the minimum qualifications which the said officers or any classes thereof shall possess for being appointed as such. My contention is because they are prescribed, they are allowed to prescribe minimum. We are not prohibited from prescribing. After adopting the minimum, we can prescribe higher qualifications. That is my respectful submission. If that contention fails, then I don't have a case.
Yes.
I'm relying on Satyapal Reddy's case itself for this particular proposition. The qualification prescribed by the government of Karnataka for the post of motor vehicle inspectors under the Karnataka General Services Motor Vehicles Branch Recruitment Rules 1976 as amended by the notification dated so and so in exercise of the power conferred by the Karnataka are as follows. Must be holder of a diploma in automobile engineering of not less than 3 years course or a diploma in mechanical engineering awarded by the State Board of Technical Education or other institution recognized by the government. Must hold current driving license or drive motorcycle, heavy goods vehicles and heavy passenger motor vehicles. Must possess following minimum physical standards. That is omitted here. In the petition itself, they have produced the rules. I will not trouble your lordship.
Yes,
That is an admitted fact, 168 centimeters.
Yes.
It is not in dispute that the qualification stipulated in the recruitment notification did not include one of the minimum qualifications, namely work experience as experience of 1 year in a reputed automobile workshop prescribed by the central government by notification dated 19th June 1989, which came into effect from 1st day of July 1989. The contention notwithstanding section 213(4) of the Motor Vehicles Act, the state has absolute freedom to prescribe qualification for the post of motor vehicle inspectors because of enumeration of state public services in entry 41, list 2 of the 7th schedule of the Constitution and corresponding enactment of the Karnataka State Civil Services Act 1978 cannot be accepted in view of the notification dated 19/6/1989 issued by the central government prescribing minimum qualification for the said post in exercise of the power under subsection 4 of section 213 of the Motor Vehicles Act of 1988 for the following reasons. Subsection 4 of section 213 of the Motor Vehicles Act of 1988 may incidentally encroach on the subject matter in entry 41, list 2, namely the state public services, but it will not render the subsection unconstitutional in view of the doctrine of pith and substance.
Correct.
Pith and substance is
Correct.
what it is has been explained, my lord. Then we come to the following the judgment is also relied upon.
Yes.
Then coming to page 103,
Yes.
para 16. When an impugned provision of law appears to touch two different entries in two lists, then the rule of pith and substance helps in characterizing the law as belonging to this or that entry. Where the question for determination is whether a particular law relates to a particular subject mentioned in one list or the other, the courts will look into the substance of the enactment. Thus, if the substance of
substance. That is pith and substance.
yes,
That is
thus if substance of the parliament, they have said that even if ancillary
will not. Yes. Then paragraph 18.
paragraph 17 may kindly. The subject matter of the Motor Vehicles Act of 1988 undoubtedly falls within entry 35 mechanically propelled vehicles of list 3, concurrent list of the 7th schedule of the Constitution. The subject of prescribing minimum qualification under said provision of Motor Vehicles Act of 1988 for motor vehicles motor vehicles inspecting officers in pith and substance also falls under the aforesaid entry as it is germane to the main matter in the entry, namely mechanically propelled vehicles, though it incidentally touches upon the matter in entry 41, list 2, namely the state public services. However, this will not render the said provision of Motor Vehicles Act 1988 as unconstitutional in view of the rule of pith and substance.
Yes. Then paragraph 18.
Paragraph 18. As the Parliament has competence to enact 213 section 213(4) of the Motor Vehicles Act, the state has no power to prescribe qualification less than the qualification prescribed by the central government. Again, I want to stress on the word less than the qualification prescribed, because the minimum qualification is prescribed by the central government. Unless the state law prescribing the qualification has received the assent of the president laid
Not
down
the
under.
question, counsel. If it is an occupied field, there is no question of any higher or lower qualification being prescribed.
It may be noticed
Prescribed
in
by
page para 21, Satyapal Reddy's case.
Yes.
May I just finish 19, my lord.
Yes.
The contention of the Karnataka, my lord, this is
Yes.
the contention of the Karnataka, the contention that the Karnataka State Civil Services Act overrides section 213(4) of the Motor Vehicles Act of 1988 in view of the presidential assent of the Karnataka State Civil Services Act of 1978 is devoid of substance. I'll pause there and I will leave it because my lordship, asked the question, I just wanted to point this out.
Yes.
And it has been rejected on the
That will not make a
principle,
difference.
on the
The
doctrine of
groups
pith and
will- They
substance.
may have to
Please.
get presidential. assent.
Coming to para 21, my lord. But we will now refer to the judgment of Supreme Court in Satyapal Reddy. The following observation made therein are relevant. Shri K. Madhava Reddy and Shri Guru Raja Rao, learned senior counsel for the appellants, contend that as the act was made under entry 35 of list 3 of 7th schedule to the Constitution, read with Article 246 of the Constitution, the act receives paramountcy, and the central government alone is competent to prescribe the qualification as to eligibility for recruitment as assistant motor vehicles inspectors, and the power of the state government to that extent gets eclipsed. And the prescription of qualification of degree in mechanical engineering becomes void since it runs in conflict with the qualification prescribed by the central government. Therefore, the state rules becomes inapplicable. The support thereof, it was further contended. In support thereof, it was further contended that other state governments had fallen in line in prescribing the qualification of diploma in mechanical engineering prescribed by the central government, and the state government of AP had not adopted that course. Since the state rule is in conflict with the central rule, and the central rule would prevail over the state rules by operation of the Article 254 of the Constitution. This is important. Next paragraph. It is the state government that operates the provisions of the Act, though its officers, therefore,
Through its officers.
Therefore, subsection 1 of section 213 gives the power to the state government to create transport department and to appoint officers as it thinks fit. Subsection 4 thereof also preserves the power by necessary implication. It also preserves the power to prescribe higher qualification for appointment of officers of the state government to man the motor vehicles department. What was done by the central government was only the prescription of minimum qualification, leaving the field open to the state government concerned to prescribe, if it finds necessary, higher qualifications. The governor has been given power under proviso to Article 309 of the Constitution, subject to any law made by the state legislature, to make rules regulating the recruitment, which includes prescription of qualifications for appointment to an office or post under the state. Since the transport department under the Act is constituted by the state government, and the officers appointed to those posts belong to the state service, while appointing its own officers, the state government, as a necessary adjunct, is entitled to prescribe qualifications for recruitment or conditions of service. But while so prescribing, the state government may accept the qualifications or prescribe higher qualifications, but in no case prescribe any qualification less than the qualification prescribed by the central government under subsection 4 of section 213 of the Act. In the latter event, that is prescribing lesser qualification, both the rules cannot prevail without colluding with each other. When the rules made by the central government under section 213(4) of the statutory rules made under proviso to Article 309 of the Constitution are construed harmoniously, there is no inconsistency in the operation of both the rules to appoint fit persons to the post or class of officers of the state vis-a-vis the qualification prescribed by the central government under subsection 4 of section 213 of the Act. Well, this is where I will pause. So my contention is based on Satyapal Reddy's case. There is no conflict. We have adopted the minimum qualification. We only prescribed something higher, having regard to the nature of work they are required to perform.
When were your rules framed? Date of your rules? Is it before or after the prescription of the qualification by the central government?
It was after, man.
Yes.
24/11/2005, at page 100 it is mentioned, 24/11/2005.
Yes.
Thereafter, coming to even the issues relating to height was.
Just a moment. Experience. Draft rules notified by the government 16/5/2011.
Yes.
Not 24/11/2005.
When-
They appear to be on 16/5/2011. Please
100
see
it is
the
mentioned.
same judgment. It is the same post,
Yes, ma'am.
same post.
No, this is.
In the present case, my lord, the rules is dated 12/10/2022. The endorsement, but may I request, my lord, I have produced the rule, annexure A1. In the present case, the rules dated 12/10/2022.
Lord, these are for the.
This was with regard to the qualification of diploma. This petition.
Well, the issue of height was also discussed in this, some of the connected matters, my lord. That is at page 111, my lord. Para 29. In writ petitions so and so, the petitioners are challenging the order dated. This is another application, my lord, not the ones which were referred to earlier.
Not in this judgment.
The applications were different. The first question arose in a separate set of applications. That was decided.
That is not what we are asking. Is it in the very same judgment that you are referring?
In the very same judgment.
Paragraph?
Para 29, my lord. So the first issue arose in the application.
In writ petition number, yes.
Which was decided on 25/5/2010 in the first paragraph. My lord. This one arose in the order dated 2/3/2010. My lord, in view of the para 29, my lord, the petitioners are challenging the order dated 2/3/2010. I'm reading it para page 115, my lord. Passed by the administrative tribunal in application number so and so. It is relevant to state that the applicants therein were aggrieved as they were not appointed by the government on the ground that they were not having the minimum height requirement under the rules. The administrative tribunal allowed the said applications by the aforesaid order dated 2/3/2010 by directing the appointment of the applicants as motor vehicle inspectors. The administrative tribunal has directed issuance of appointment orders inter alia on the ground that several other candidates who did not even possess the prescribed qualifications have been appointed. It is relevant to refer to the following reasoning of the administrative tribunal. Lord, it is noticed that the tribunal says that other ineligible candidates have been appointed, therefore appoint them also. So the High Court holds.
Yes.
The above reasoning of the administrative tribunal is erroneous and unsustainable in law, as observed by the Supreme Court in State of Haryana versus Ram Kumar Man, who two wrongs can never make a right, and accordingly a wrong order of the government does not confer a right to claim parity or equality. Similarly, in Fuljit Kaur versus State of Punjab, it is observed that Article 14 of the Constitution, it is not meant to perpetuate illegality. A wrong order in favor of one party does not entitle any other party to claim benefit on the basis of such a wrong order. In view of the confirmation of the order dated and dismissal of the writ petitions referred to in para 1 above, the order dated so and so 2/3/2010 of the administrative tribunal passed in the application referred to at para 29 above, directing issuance of appointment orders is liable to be set aside, and it is accordingly set aside. Lord, I'll pause here. Lord, my reciprocal submission is there is no repugnancy because the central government legislation mainly only prescribes minimum qualification, and all that the state government has done is prescribe a higher qualification, which
See, simple. Your minimum qualification and central government minimum qualification are in conflict. That's how it has to be looked into. You are terming it as
is in addition to what has been prescribed by
higher
There
qualification.
must be power to prescribe the qualification.
well, power to prescribe is provided under Rule 3 of 230.
Yes.
Lord, now the residential value of an interim order, my lord. Lord, I'm referring to a judgment of Andhra Pradesh High Court, which refers to Supreme Court, well-known Supreme Court decision, my lord. I'll just pass this.
Yes.
Lordship may kindly refer to para 11, ma'am. Judgment rendered by Justice S.B. Sinha. It is now a well-settled principle. I come to para 11, madam.
Yes.
It is now a well-settled principle of law that the ratio of a judgment is the reasons assigned in support thereof. While a court of appeal stays the operation of the judgment, it stays the further implementation as between the parties of the operative portion thereof, and thereby the ratio of the decision cannot be said to be wiped off.
Yes.
But, what I want to stress in the first paragraph is it states the further implementation as between the parties, my lord, in the very first sentence
Yes.
of the operative portion thereof, and thereby the ratio of the decision cannot be said to be wiped off. Furthermore, a distinction must be borne in mind that the appeal court may, in a given situation, also suspend the operation of the said decision. Suspension of operation of a judgment and staying the operation of the order, in our view, connotes two different situations. In Yella Reddy versus so and so, a division bench of this court considered the decision of the apex court in Indira Gandhi versus Rajanaran, holding it is admitted by the learned counsel for the petitioner that the judgment of the full bench of this court has been stayed and the operation of the judgment has been suspended by the Supreme Court, but the argument is advanced, placing reliance on the decision of so and so case that the effect of suspension of judgment of the High Court is only that the judgment shall not be implemented by the dicta decided in the judgment decided in the judgment remains operative and is binding on the single judges and division benches until the judgment is set aside by the Supreme Court. Though we do not agree with the statement of law and feel the principle to have been very widely stated, yet ordinarily the matter to have been placed before the larger bench is
We don't have any argument with that. We are aware
and
that of the
the
presidential value of an interim order.
So it is
Yes.
only as stated by the state government in the endorsement, the interim order is only applicable to the parties to that case, my lord. And therefore they have been given appointment. Therefore, my contentions, my three main contentions are that the writ petition cannot be maintained or the applicant could not have challenged the selection process or the prescription of height on the ground that it violated the central government legislation. Because he participated in the selection process without any demur and he has no right. My learned friend has not pointed out any exceptions to this well-settled principle. Therefore, he cannot, the list itself is not maintainable. The second contention is that there is no conflict between the central legislation and the state legislation because it's only an additional qualification while accepting the minimum qualifications. And the third contention is the endorsement is correct because the interim order will only apply to the parties to that case, and it will, my lord, the decision of the division bench will continue to apply as a precedent, although the order remains suspended because of the stay, as pointed out in this case.
Yes.
So the decision of the division bench of this court, insofar as the height is concerned, will still continue to bind this honorable court, division bench as well as the single bench.
Is the entry in 7th schedule concurrent list?
Concurrent list.
35. 35.
35.
Can you-
41.
Please condition.
41 in list 2.
Sorry, state list. It's entering of the
List 2, my lord, entry 41.
Describe the conditions of services. Particular case, where the details. If the entry itself is there in the.
Let me discuss. So can we say this increment of 31 into service, state public services is minus the poverty upon
Where would be the problem for something? How do you- Supreme Court has done it. How do you- beyond what it is. How do you then present it on the- Specifically, I think about it. This is insane. Will be issued at the- So, 20 is higher qualification. If there is the power, residual power, it is later on. This is like after. Here at least there is no such residual power. But number two, you have to pay. So it has to be under this law. Substance are given of also. Supposed to be English. Yes. What? Yes.
One day, do not pass. I refer to page 100 of the bill. This date was the amendment only relating to
Clarification.
2411. So this case is entirely related to that. So the provision enabling in-service candidates to be promoted. For the
Yes.
That is an
Oh, it comes only in 22. And therefore, the qualifications for the direct recruits have been adopted here. This is what happened. Yes, what your contention appears to be that whatever is the provision with regard to additional qualification, all that is hanging fire in the Supreme Court. This is not a regular appointment and it is not a direct recruitment. This is an appointment by transfer. He has a contention that there are vacancies. In the light of the interim order of the apex court, appoint him. Ultimately, that is this. He cannot claim any.
They don't succeed.
Then he cannot claim any equity on the basis of the appointment that he is being given. Why should we go into all these questions in this detail? It is only good that we have had this. Yes. We'll say that, please give the. We have heard the learned counsel for the petitioner quite an extensive. It is submitted by the learned counsel for the petitioner that the petitioner who was working as
First division assistant.
first division assistant in the motor vehicles department had applied pursuant to a notification for appointment by promotion to the post of motor vehicles inspector. It is submitted that he was found to meet all the criteria provided in the notification which was produced before the tribunal as
Annexure A1.
except the qualification with regard to minimum height as provided therein. He had approached the respondents and by impugned endorsement dated 15/4/2023, his request for being considered for promotion stood rejected. He challenged the same before the tribunal, filing application number 2322 of 2023. Had you filed objections?
Yes.
You had. The application was resisted by the respondents, official respondents, by filing written objections. The tribunal, after considering the contentions advanced, before that, the petitioner had raised contentions before the tribunal that the provisions with regard to minimum height were to be found in the cadre and recruitment rules for the post of motor vehicles inspector, which provided a minimum height of 168 centimeters. The specific contention was that such prescription of height was non-est in view of the fact that the central government, which is empowered under Section 213(4) of the Motor Vehicles Act, had issued notification prescribing the minimum qualification for the post, which did not contain any prescription with regard to height. It was pointed out that with regard to direct recruits, a similar contention had been raised, which had been accepted by the tribunal. However, this court had interfered by its judgment dated (23/9/2024) in
2014.
WP number 880/2010 and connected lines.
and so on, so full stop. It is submitted that the apex court in SLP number 32186 to 32199 of 2014 by order dated 30/8/2022 had directed the appointment of persons without considering the qualification with regard to height as provided in the cadre and recruitment. However, it is contended that since annexure A1 notification specifically provided that the selection criteria for appointment by promotion, which was incorporated by an amendment to the cadre and recruitment rules made on 12/10/2022, specifically provided for the same standards as prescribed for direct recruitment. The petitioner would also be entitled to be appointed since he satisfied all the other criteria except the height. Full stop. The learned counsel for the petitioner places reliance on the judgments of the apex court and so on, so that.
This may be the judgment, my lord.
Just a moment, just a moment. The learned counsel for the petitioner places reliance on the judgments of the apex court in this compilation to contend that the petitioner would also be entitled to be appointed without reference to the qualification of height. The learned government advocate appearing for the respondents, on the other hand, contends that the order of the apex court is only an interim order, and that the question whether the state can prescribe qualifications additional to the minimum qualifications prescribed by the center is being considered by the apex court in the SLPs, full stop. Our attention is also drawn to the judgment of this court from which the SLPs have arisen to contend that the that this court had considered the judgment in Satyapal Reddy versus State of AP, 1994 4 SCC 391, where it is stated that the state government can accept the qualifications prescribed by the central government or prescribe higher qualifications, but in no case can they prescribe any qualifications less than the qualifications prescribed by the central government under subsection 4 of section 213 of the Act. Full stop. It is contended that since the question with regard to the necessity of the qualifications is still being considered by the apex court, the petitioner cannot claim any relief on the basis of the interim orders of the court, of the apex court. It is further contended that the writ petition, the application which was filed without making the parties likely to be affected by the rejection or by the acceptance of the petitioner's candidature as parties to the application was bad, and that this writ petition is also therefore not maintainable. The learned counsel for the petitioner draws our attention to annexure A1 recruitment rules, which specifically states that the qualifications for promotion in the 5% category will be as provided for direct recruits. Full stop. It is further contended that it was a specific case of the petitioner before the tribunal that there were several vacancies available and that the petitioner is not claiming any benefit as against any other selected person and is only claiming an appointment, dehors the height requirement in the light of the judgments rendered by the apex court, as also the fact that the interim order of the apex court has been given effect to and 33 persons have been appointed by direct recruitment without reference to the height qualification. Full stop. Having considered the contentions advanced and in view of the arguments advanced on both sides, we are of the opinion that in view of the fact that the recruitment rules as well as the notification specifically provides that the physical requirements will be as per the requirements for direct recruitment. The petitioner's case cannot be differently dealt with by the state. In view of the fact that the state has already afforded appointments to 33 persons by direct recruitment without taking note of the requirement with regard to height, we are of the opinion that the writ petitioner herein is also entitled to the same relief. This is more so in view of the fact that the appointment is by promotion, and in case the contentions of the state are accepted and the special leave petition in which the interim order is passed is dismissed, the state would not be put to any prejudice, since the petitioner cannot claim any equity since the promotion is being granted specifically on the basis of the interim order passed by the apex court. With these clarifications, this writ petition is disposed of directing that the petitioner shall also be granted the promotion, dehors the requirement with regard to height. It is made clear that the promotion so granted shall be provisional and subject to the final orders in the SLP. Okay, okay. For the order of the tribunal as well as the endorsement rejecting the application made by the petitioner shall stand set aside for giving effect to the directions as above.
Not.
It is here, you got it. Is it on the point? I don't remember whether it is. With reference to UGC and state, it is there, but there the difference is that UGC, the entry in the union list does not cover the question of qualification. Only the qualification, not the age of retirement. Are we right?
Yes.
Age of retirement.
Only the age of retirement is nothing.
I'm not saying that is not the decision I'm referring to. On this very point, Motor Vehicles Act, there is a decision.
Not
I don't know whether, probably I am mistaken. Maybe there is, no, because you can't always rely on your memory alone. Maybe it is on some other distinct point. But it was, if I remember correctly, it was an Association of Motor Vehicles Inspectors of Kerala. And it was with regard to qualification. It was under 213(4). If I remember right, this stands covered. 3 weeks. 3 weeks. One month.
But item 30. My case is more deserving, my lord. My case is more deserving than his, my lord.
We'll have to hear you. Unless we hear you, how can we decide whether it is more deserving?
I am a direct recruitee, my lord. Identical circumstances, my lord. I am a direct recruitee.
We'll have to hear you.
Please, my lord.
Without hearing, we cannot
Please,
pass orders.
please, my lord. I am ready, my lord. I am ready, my lord. I am only saying that I am more deserving candidate than his.
If you are a more deserving candidate, you probably will get a better order.
Please,
which does not say that it is dependent on somebody else arguing their case.
Therefore, my lord.
Yes.
Date may be fixed, my lord.
Yes.
My lord, I'm
Yes,
sorry
Counsel.
to trouble my lord at this time. Item 31, my lord, any date which is parted, my lord, the state was to get the service register. This is in relation to Article 371. Would your lordship kindly, if your board permits, next Friday at 2:30, my lord? I don't know about your lordship's board.
Dear
Therefore,
Counsel.
my lord, I can only make a request. If I, subject to your
Dear
lordship.
Counsel, we can also only say that if it permits, let us try next Friday. May not
2:30.
be possible. Sorry, it may not be possible. We'll give you a listing
Very
as
well.
soon as possible.
Very well.
My lord, a submission, my lord. My lord. A submission, my lord. I
Yes.
request your indulgence, madam. This is regarding upgradation and downgradation of senior geologists in the mines of in the Department of Mines and Geology, my lord. Two cases were connected together. One case has been reserved for judgment, my lord. In the connected case, it has been adjourned without giving a date. So there is urgency.
It will be listed on the date when the matter is posted for judgment. So that on
Please.
the basis of that, we can
Please,
decide on the other one as well.
please.
Tuesday is not possible, I'm sorry. She'll give you dates when it is humanly possible. Please bear with us.